All those having business before this honorable court may now draw near and they will be heard. God save the United States and this honorable court.
Please be seated. Good morning. We have with us on the video our esteemed colleague, Judge Ebell, and the wonders of modern technology allow us to pull this thing off. And so we hope. And we'll fake it anyway. The first case we have this morning is 21-1414 Doe versus Board of Regents. Would counsel for appellant make the appearance and begin, please?
Good morning, Your Honors. Michael McHale on behalf of Appellants, and with me today is Peter Breen, co-counsel. May it please the court, and just as a preliminary, I'd like to reserve 3 minutes for rebuttal if possible.
If possible is the operative phrase. Go ahead, please.
Right. In August of last year, the University of Colorado Anschutz School of Medicine adopted a religious exemption policy to its COVID-19 vaccine mandate that violated the First Amendment in a manner rarely seen in modern times. The policy limited religious exemptions solely to those who possess, quote, a religious belief whose teachings are opposed to all immunizations. In other words, if you belong to the wrong religion, you were out of luck. That policy doubly violated the First Amendment's clearest command against denominational discrimination and its promise that, presumptively, the state may not restrict practices because of their religious nature. And the defendant university officials applied this policy pervasively and perniciously, and all 17 plaintiffs were denied accommodations under the September 1st policy.
And that's the policy that I thought you were talking about, and that policy has been rescinded, hasn't it?
So the plaintiff's position is that the September 24th policy, looking at the evidence in its totality, is effectively applying the September 1st policy. So formally, yes, the university on September 24th updated its policy and made the new criteria whether one could perform remote work entirely. But looking at the evidence in its totality, it's clear that there's at least a slight suspicion that what's really happening is a continued distrust of plaintiffs' religious opposition to COVID vaccines. And that's why...
Looking at the record in its totality, well, what is it in the record that is concrete in the September 24th policy that would lead you to believe that it's implicitly applying the September 1st? That's the first question, and I'll let you answer that, and then I'll move on.
Right, it's the way it's being applied primarily. So 3 of these plaintiffs work entirely off campus and were on their way to or actually received religious accommodations from those facilities, and yet they're told by the university that they're an undue burden or an undue hardship, that they're a danger somehow to these facilities that wanted them. But what really that gives rise to an inference that what's really going on is they just have the wrong religious belief. It doesn't make sense that they're excluded by the university. Also, the disconnect.
That they're forced to work remotely, is that what you're saying?
Actually, the plaintiffs who are healthcare providers and were on their way to or received accommodations from the facilities they worked at to do in-person work even. Also, the disconnect between the defendant's policy and the State Board of Health's policy. So the defendants say they enacted their policy in view of the State Board of Health, but the State Board of Health allowed religious accommodations in person from the beginning, and then in December actually encouraged them by allowing religious accommodations at facilities to count towards a vaccine rate. So that disconnect there is a sign.
Just to be clear, this encounter took place under the September 24 policy.
Could you repeat the question?
This encounter you're talking about occurred under the September 24 policy, not under the first policy. Is that correct?
I'm not sure that's correct, Your Honor. All 17 plaintiffs.
But which was it? You ought to know which one. Just tell us.
All 17 plaintiffs were denied accommodations under the September 1st.
Was it after September 24?
Initially, no. All 17 were denied before.
No, this encounter that you described, was it after September 24?
I'm not sure what encounter you're referring to, Your Honor.
You said they were on their way to work and told that they couldn't come.
Right. Jane Doe 1, for example, worked 60 miles away at Children's Hospital, and she was on her way to an accommodation. Her supervisor said that she was a model employee.
I understand that fact. I'm just asking a simple question. You could easily answer just yes or no and then move on. Did that encounter occur before or after September 24? It's not a hard question.
You were discussing the one related to Jane Doe number 1, right?
Yeah.
Well,
What you referred to just now, your example that you were presenting to the court, I just want to know when it happened.
Right. Jane Doe 1 was before September 24th, but then she was later told after September 24th that she would be an undue burden. And Jane Doe 11, similarly, was actually granted an accommodation by her facility more than 100 miles away from campus, and then she was told after September 24th that she would be an undue burden. But when there's that kind of over-inclusivity, and Lukumi, the Supreme Court was clear in Lukumi, when there's this over-inclusivity, when it's clear that the burden on religion isn't actually necessary to achieve the government's interests, that gives rise to an inference of religious animus or religious non-neutrality. So here, Jane Doe 11, taking her example, she actually received an accommodation from the place she worked at, and yet she's still fired. But clearly, her facility didn't view her as a danger. So that's the kind of over-inclusivity that gives rise to an inference of here, even just religious distrust. And the Supreme Court standard is even a slight suspicion raises the bar and requires heightened scrutiny. And that's because of, go ahead.
There was something you said when I initially spoke about the September 1st policy, though, that raises a question for me. If the notion is that somehow they're implicitly applying some of the constraints of the September 1st policy through their implementation of the September 24th policy, it still doesn't answer the question for me that I had in my mind of why we can't just deal with the September 24th policy, because there it goes towards the application of this policy. It is being applied in an unconstitutional way. My point being, the September 1st policy, it seems to me, is dead and gone. I mean, I don't understand, even if your argument is that the sort of the spirit of it lives in the September 24th, the application of September 24th policy. Well, why don't we just strike down the September 24th policy? Wouldn't that give you what you want?
So as to the mootness issue, it doesn't necessarily as to Jane Doe 2 and Jane Doe 9 at the very least, because they were not reevaluated. But even if you're right, I would say absolutely. The September 1st policy still informs the neutrality analysis of the September 24th
Well,
policy.
it may, but it doesn't mean that September 1st policy still has vitality in terms of a vehicle for relief. In other words, if you're saying that the September 24th policy, they are sort of implementing sub salientio the September 1st policy through that. Well, why wouldn't it give you full relief to strike down or to enjoin the September 24th policy in all its permutations?
Well, it's just a basic application of the court's RESAC opinion, but
No, and well, why is that? I mean, the point is, it's one thing to say, RISAC talked about lingering effects of, And number one, there were only one policy at play in RISAC, not two. Lingering effects of that policy. Well, if you're saying that the lingering effects of the policy are at work through the implementation of the September 24th policy, why can't we just deal with the September 24th policy?
Even if we're wrong about that, Your Honor, absolutely. An injunction against the September 24th policy would provide significant relief here because of this disconnect, these issues I'm raising about the manifest religious distrust that seems to be, at least gives rise to the suspicion that triggers strict scrutiny. And another key is that the September 24th policy is non-neutral even on its face with its explicit bar on religious exemptions for students. An accommodation request by a student turns entirely on the religious character of that request. But that's what the Supreme Court in Trinity Lutheran and Espinoza and lately in Carson, when the government's burdening someone because of their religious character, that triggers strict scrutiny. Also, that is another vestige that tethers the September 24th policy to the distrust that initially occurred.
That led to the implementation of the September 1st policy. Go ahead,
Lukumi, just looking underneath the language is required in free exercise analysis under Lukumi to survey meticulously the facts and circumstances that led to. So even if the September 1st policy as a formal matter is gone, yes, and even if you're correct about that, the September 1st policy is still a key part of the history. And then they also applied the September 1st policy in October. So after September 24th, supposedly everything had changed, but they told Jane Doe 1 in briefing in response to our motion for a preliminary injunction that the reason she was still ineligible, or a reason, is because surely she must be aware as a bioethicist that drugs like Tylenol and aspirin are connected to abortion. Also at the same place, they contrasted her views to the Vatican's official teaching office. This is under the September 24th policy, allegedly. There's a continuity that just continued, and that gives rise to at least the suspicion that triggers strict scrutiny.
For better or worse, I'm going to allow a little liberality here on the time, and so let me just ask one question because I want to make sure I know the answer to this related to RISAC. Let's assume for the moment that I want to understand why RISAC would not be just limited to the prison context. I mean, because the cases that it cited were prison cases, and what struck me in RISAC is the prisoners had very little ability to change their circumstances. In other words, the lingering effects idea, I'm still not an ADX, well, and shouldn't that solve the problem, but I'm in another facility? Well, it was very difficult for them to avail themselves of some mechanism to get out from under that. It seems to me that constraint is not necessarily at play here. I just want your response to that and we can move on.
My immediate thought is, as to students, the students are completely restricted now from even applying, so they're under a kind of constraint that they can't get out from under.
But that's 24th policy, right?
It's 24th policy, right? It's but it's the lingering effects issue, that there's a lingering effect there insofar as students are completely bound and unable categorically to apply. So giving them some type of process at least to seek accommodation on equal terms with employees and students who they can seek medical exceptions, another sign of the disparity there. That would be fitting, I think, within RESAC still. That's my thought, but
okay.
Yeah, so much, there's just manifest and overwhelming evidence. Another key piece of evidence is illogical and shifting explanation by the university for the September 24th policy. So they said that the reason they needed it was because of an increase in COVID in September of last year, but yet Chancellor Elliman in his declaration said they had granted 0 religious exemptions under the September 1st policy, and they've only acknowledged granting 2 medical exceptions. So it's not clear what needed to change and become more restrictive. But then before this court, Chancellor Elliman, in a supplemental declaration at the IPA stage, said the reason they changed the September 1st policy was because it's vulnerable to litigation. So which is it? An increase in COVID, even though they hadn't granted any religious accommodations under the September 1st, or vulnerable to litigation? This kind of shifting justification when there's an ongoing religious burden, and a lot of healthcare professionals are completely terminated from providing healthcare, even though they were granted, some of them, granted accommodations at their satellite facilities, gives rise to the suspicion that what's actually happening is not an undue health hardship or anything, but a distrust of their religious beliefs, and that distrust was manifest.
Let me ask you a question. It was my understanding that from your briefing that your view is that medical exemptions are comparable secular activity to religious exemptions. Is that right?
That's right.
Well, isn't there a distinction in that medical exemptions in the current shortage of medical personnel serves to facilitate treatment at the facilities? I mean, whereas the religious exemptions are not similarly situated, are they?
I'm not sure I agree, because religious exemptions for healthcare workers to continue providing treatment would seem to serve the same interest, would seem to serve the same interest, I would say. Also, Carolyn Brownwell, the Associate Vice Chancellor, made it very clear that
Well, the numbers are different, though, aren't they, in terms
The
of
numbers
people affected?
total exemptees. So the First Amendment, Justice Gorsuch made this clear in his Dr. A dissent, which was just an emergency appeal denial. So it was a non-merits denial by the Supreme Court. Gorsuch, so his point was that the First Amendment requires a one-to-one analysis when you look at the general applicability analysis. So it's each plaintiff as compared to another single plaintiff. And then you can take the numbers into consideration at the strict scrutiny stage. And that seems to make sense. Also, the district court said that the numbers game somehow tilted against students here, because students could outnumber the amount of employees who seek exemptions, and that would create the numbers disparity. But obviously, the employee number far outweighs the student number at the university. But regardless, I'd go back to the one-to-one analysis that's required. And the university's been clear that it's being unvaccinated and the possibility of spreading COVID, that's the harm they're trying to get at here. And a medical exemptee undermines that interest to the same extent on a one-to-one basis as a religious exemptee. And the September 24th policy just by itself is also non-generally applicable, and this is important. They allow, taking that policy exclusively by itself, students and employees to work alongside the unvaccinated at affiliate and non-affiliate sites. So they allow the same kinds of harms working alongside the unvaccinated that they say these plaintiffs pose. That's the exact kind of harm under Tandon that triggers strict
Did you raise the question of not sufficiently inclusive, that is under responsive to the problem in your briefs? I didn't pick that up as an emphasis argument of yours. That's a discrete, separate argument, and you argued that it was insufficient, and that is a reason for what? What conclusion should we draw from the fact that this is insufficient to cover the entire problem? I mean, almost every piece of legislation that's ever been passed doesn't 100% solve problems. We deal in the practical and the pragmatic, and not the perfect. So I'm kind of at a loss to understand, number one, whether you really are asserting under-inclusiveness in your briefs consistently, and secondly, why is that such a terrible problem here?
We did assert at 4 different levels of under-inclusivity, but in particular, the fact that the defendants allow their employees and students to work with the unvaccinated at affiliate and even non-affiliate sites, which poses the same type of risk to their interest. That's the language in Tandon. If it could pose the same type of risk, that triggers scrutiny. And the difference there with the other types of legislation, Your Honor, is this is First Amendment religious exercise. There's an ongoing substantial burden, and the First Amendment has a special solicitude in that situation. So we look with heightened scrutiny at under-inclusivity in a way we don't necessarily do in other contexts.
I see your time has expired, but that answers my question. Thank you.
Honors.
Thank you.
Good morning, Your Honors. May it please the Court. My name is Dr. Jacqueline Rich Frederick, Special Assistant Attorney General. Along with my co-counsel, I represent the University of Colorado Board of Regents and other defendants in this matter. The University of Colorado's medical campus, as well as its employees and students, have provided vital health care services to the most ill and at-need Coloradans. This essential role was particularly acute during the 30-plus months in which the COVID-19 pandemic has ravaged Colorado, sickening more than 1.6 million people and claiming nearly 14,000 lives. The fall of 2021 was a particularly challenging time. In response to rapidly increasing case counts, the university promulgated its September 1st COVID-19 vaccine policy. 3 weeks later, that policy was repealed and replaced with the September 24th policy. The policy requires all employees and students of the university to take one of then 3 available vaccinations. Plaintiffs here are unlikely to succeed on the merits of their challenge because the university's September 24th policy survives the Smith rational basis test for 2 reasons. First, the policy's purpose is rationally related to a legitimate governmental interest. In short, the goal is to save lives. Second, the policy is both neutral and generally applicable. No CU employee or student who is unvaccinated may come to the medical school campus or have contact with patients. Because plaintiffs have not met their burden to show that they are substantially likely to succeed on the merits, the district court correctly denied their motion seeking preliminary injunctive relief. It is true.
When you say it's neutral, frankly, the one clause that gives me pause in the September 24 policy is the phrase, religious accommodations are not currently available to students or applicants. Was there a similar statement for medical or other kinds of accommodations also not being available to students and applicants?
No, Your Honor, because medical exemptions are available to students. The only exceptions available under the policy are for all people, medical exemptions, for employees, Title VII compliant religious exemptions.
So, as I understand your argument, the reason that, I guess that you acknowledge that religious prohibitions are distinctive, that religious people are being singled out, but you are justifying it because Title VII allows that for students and applicants. Is that the summary of your argument?
Your Honor, as to the distinction between the treatment of students and employees, students are not granted a religious accommodation under Title VII. It doesn't provide for that. The university's policy is designed to provide all of the required exemptions while maximizing their trio of goals, which include individual and public health, i.e. to safeguard patient, employee, and student life safety.
Well, Counsel, why would a distinction between students and employees further that goal?
It would further both that goal as well as the 2 additional goals, which are to limit transmission of the highly transmissible virus.
I take those as a given. Let's just take those goals. Those are a given. Why does your policy, which does not let students apply for religious exemptions, serve those goals?
It serves those goals because it maximizes the number of vaccinated persons on the campus and interact.
Is that it? It just keeps students from coming on campus. There's no distinction actually between students and medical providers other than the numbers. It's just getting rid of numbers.
Your Honor, it is both numerical as well as tethered to the fundamental distinction between a medical and a religious exemption. So yes, as I believe the court discussed with opposing counsel, the record does reflect that the university received more than 200 religious exemption requests. Comparatively, it received only 79 medical exemption requests, of which only 11 were granted. It is true that it is
But is there a distinction between students and medical providers, other than numbers? In their risks or their whatever else that they present?
As human beings know, as to their job duties or potential interactions with the campus, yes.
Okay.
Medical students at the medical campus have as part of their core training obligations to participate in clinicals. That places them in a situation where in order to progress through their education, they have to be able to have those on-campus, in-person interactions through those clinical experiences. That is analogous to, for example, Jane Doe's 1, 10, and 11, who have at the heart of their obligations, core duties, to provide care, for example, as Jane Doe 1 does, to critically ill infants in the NICU. That is dissimilar from, for example, plaintiffs, such as Does 4, 5, 6, and 7, all of whom were able to be successfully accommodated because their core job duties could be performed either off campus or remote on campus. And so it is both in furtherance of what Biden versus Missouri recognized as the opposite of efficient and effective administration, as well as for the numerical purpose that the court has recognized here today.
The school had no remote learning opportunities for students during the height of COVID?
The school did work towards remote opportunities during COVID. However, students are required to complete in-person clinical rotations as a core part of their curriculum. There's a difference between, for example, a student who is at the end of their program of study and may have only coursework left. That can be addressed remotely. Clinical experiences, the treatment of patients, must occur in the clinical setting. And for that reason, John Doe's 6 and 8 could not be accommodated because they were brand new students pursuing a medical certification as well as an anesthesiology credential. And each of those required them to be in intimate contact during their clinical rotations with patients.
Well, but the line that's drawn is employees and students. There are surely some employees that are also in intimate contact with patients, and they nevertheless may seek a religious exemption. Is that not right?
They may seek an exemption congruent with Title VII, and the university accepts at face value, though they could inquire under the law, the sincerity of their belief under the September 24th policy, and then turns to an analysis of whether they can be accommodated without undue hardship to the institution. Through that analysis, the university has successfully accommodated 7 of 13 employee plaintiffs, more than half.
Oh, that's more than half. That's a good thing. Then why doesn't the university try to do that with students? I mean, if this is a numbers game, this goes back to the fact that we're talking about individual constitutional rights and burdening an individual constitutional right so that you can, in the aggregate, reduce the number of people on campus who have potential for COVID. I'm not sure the Constitution contemplates that. And if so, give me the best case you have that says it does. Numbers game.
I would say Biden versus Missouri's recognition that the inclusion of a medical exemption to avoid sickening employees and students allergic to the vaccine demonstrates consistency with the university's goals in this case. I would also point the court to Hochul out of the Second Circuit, which dealt with a policy that had in place likewise exemptions for employees, not for students, and which the Supreme Court declined to overturn.
Well, that doesn't tell us anything, as you know. If the Supreme Court if you're saying the Supreme Court denied cert, I mean, that doesn't tell us anything. And so as it relates to the students, then what is the difference between a student getting a medical exemption and a student getting a religious exemption that doesn't have to do with the numbers?
At the end of the day, Your Honor, the university is consistent that no person who is unvaccinated may be on campus engaging with, in particular, patient care, regardless of whether the exemption that they seek is medical or religious in nature.
I thought you said you accommodated 7 people who were employees who were able to interact with patients. Did I? Okay, let me reframe it. You're telling me that there are no employees now who are interacting with patients who are under exemptions?
Who are unvaccinated.
Who are unvaccinated.
That is accurate, Your Honor.
All right. And so in terms of students, if those students have a medical exemption, they are not permitted to interact with patients?
Correct.
And under what circumstance is that possible? What's the nature of an exemption if they can't interact with patients?
If they are able to be exempted from the requirement because taking the vaccine would cause them to themselves be ill, contrary to the university's public health goals and the maintenance of hospital staffing levels, then the analysis turns upon whether they can be accommodated in a manner that does not present an undue hardship to the institution. If they would be required, in order to complete their studies as a student in this case, to interact with patients, they could not do so safely without imposing undue hardship upon the institution because it would impose life safety risk to the critically ill patient.
Well, this filter of doing an undue hardship analysis, that's not even permitted to students who are seeking religious exemptions. I mean, they don't even get in the game, right? They blanket or prohibit it.
They are not eligible for a religious exemption under the September 24th policy. That is correct. However, the case law bears out across...
So I have two further questions also on this religious accommodation. The word applicants, what does applicants refer to? Is it applicants to be students or applicants for employment?
I cannot say with certainty, Your Honor, without the policy in front of me, what it is modifying in that particular sentence, but I anticipate that it would be student applicants if it is addressing ability to access religious exemption, all applicants as it addresses medical exemptees.
So you're thinking, I mean, will we find the answer to that question in the record someplace? This doesn't relate to job applicants, but only student applicants?
I would commend to the court the affidavits, declarations of Chancellor Elliman, and that addresses as well as, and that's going to be Exhibit E. There would also be relevant information in Exhibits B and C, which are the attestations of those who precisely undertook the analyses for both medical exemptees as well as religious requests for exemption, which addresses the fact that they are treated likewise.
So your position is that you think the record will support that applicants refers to people that are applying to be students. Is that correct?
That is what I would anticipate, Your Honor.
All right, then the second question
that's not
is...
a yes, though. Are you taking a position or you're not?
I'm not sure where in the policy the word applicants with the specific question is with regard to which particular part of the policy in which the word applicant appears, which the court is asking.
It's the sentence we've been focusing on the entire morning. Religious accommodations are not currently available to students or applicants.
That would refer to expressly students, current students, applicants for student status. That does not include employees.
Okay, all right. Okay, then my second question is, we're familiar with the concept of severability in statutes. If there's something unconstitutional in a statute, we ask, is it severable or isn't it? That's a question that has to be decided. I'm not familiar with the application of that concept for the policies of private people like the university that is non-statutory. But if we found that sentence questionable or unconstitutional, could that be severed from the policy, or would that require the entire policy to be stricken?
I think it could be severed. I do not believe that it is unconstitutional, Your Honor.
That wasn't my question though, but is it the university's position that it could be severed from the policy and the rest of the policy kept in place? Or would it be that it's part of the policy, and if that part is unconstitutional, the whole policy falls?
I do not believe the whole policy falls, Your Honor. The policy is consistent in aggregate with or without that single sentence, in that it extends required medical exemptions to both employees and students and provides the opportunity for religious exemption congruent with Title VII to all employees. It is consistent with...
Thank you. That answers... I don't want you to run up the last bit of your time. Thank you.
Thank you, Your Honor. Courts have consistently applied the rational basis test and found that vaccine policies support legitimate governmental interests. That's Doe and Mills, Hochul, Clausen, Children's Defense versus Rutgers, Atunes versus UVA, Bush versus Fantasia, and Valdez, a District of New Mexico case, which an iteration of this court affirmed the denial of a motion seeking preliminary injunction and cited favorably language from the district court in that case stating that stemming the spread of COVID is a compelling governmental interest. The Supreme Court has gone further and observed that curbing the spread of COVID-19 is unquestionably a compelling interest. That's Roman Catholic diocese. An unquestionably compelling interest is inherently legitimate. For that reason, the university's policy is a legitimate governmental exercise which passes rational basis. It is also generally applicable and neutral.
Well, on the neutrality point, what about the argument that we've heard this morning and in the briefs about, I don't know, the word animus was not used, but citing Lacume, the notion that there is this, at a minimum, negative reaction by the university to those who seek to exercise their religious rights as opposed to others. How does that, and as these play out in terms of the individual does and they're seeking accommodations, that is the inference that that the opposing counsel draws. Were that to be in fact what we see in the record, that's a game changer, right? I mean, that alters the analysis of how we go about looking at this, because it's not a facially neutral policy in which we're trying to discern burden, but it's one in which you're, as in Lacume, targeting religion, right?
If there was animus, yes, it would alter the analysis. There is not animus in this instance. The policy of September 24th is facially neutral. It requires all employees and students to take the vaccine. It is also neutral in that it was not put in place to discriminate. The object of the policy is consistent to further public health, maintain staffing levels, and save patient lives. That is non-discriminatory. The policy was expressly amended in furtherance of those goals in light of rising case counts and to ensure non-discriminatory application of the policy itself, as attested to by Chancellor Elliman.
Let me understand one thing about the amendment from adopting the September 24th policy. When you adopted that, what was the university's express approach to the September 1st policy? In other words, did it declare it to be null and void, one, and essentially disclaim the terms of that policy? And how is that framed? Because, I mean, part of this argument about mootness is the ghost lives on of the September 1 policy. Well, part of that ghost would live on, arguably, if the university was essentially allowed it to float out there. You know, we've got a new policy, but we're not saying that anything in that other policy was wrong or problematic or that we won't do it again. What is in the record that speaks to what the university's policy is vis-a-vis the September 1st policy now that it's adopted the September 24th?
The answer to the court's first two questions are yes and yes. This is not a haunting, Your Honor. The September 24th policy is a repeal and replacement. Chancellor Elliman's declaration states that explicitly. Declarations B and C likewise clarify that a new group of individuals was brought in to assess application of the new policy as it regards evaluation for religious exemptions. Under the September 24th policy, and has been consistently done now for more than a year, the university forgoes inquiry, though permitted by law to do so, into the sincerity of someone's faith belief and moves promptly to the second prong. As soon as someone has asserted that they have a belief, the university takes it at face value, making no further inquiry, and instead considers if the core job duties can be accommodated without an undue hardship.
Counsel, can I just stop you there? So you're telling us that there was no inquiry into the sincerity of the belief? None, zero. Once September 24th happened, there was nothing.
That is correct, Your Honor, and the record reflects the same. All currently employed individuals were reevaluated under the September 24th policy, which led to 7 of the 13 employee plaintiffs being accommodated.
But you concede that there was, I guess, you looked into the sincerity of the beliefs before September 24th.
Under the September 21st policy, as permitted by the law, the university did ask, is the belief sincere? The university is no longer engaged in that inquiry, though the law does permit them to do so.
Under the September 24th policy?
Under the September 24th policy, they do not make that inquiry.
Okay.
But then why? I'm sorry. So you made it before, and you're not making it now. What was the justification for that?
Ultimately, the September 1st policy, which is moot, was drafted to be congruent with Colorado State Statute 254901, which is the school vaccine statute. There was an additional inclusion of the word all, which created a bit of an inartful implementation of that policy. And as such, and as reflected by Chancellor Elliman, the university they repealed and replaced that policy with a September 24th policy to make explicitly clear that both in policy and practice, the university welcomed employees to seek a religious exemption and takes them at their word as it regards their sincerely held faith beliefs, and simply inquires into whether the job duties may be accommodated without undue hardship.
But you continue to take the position, I'm sorry to keep pushing on this, but you take the position that it would be fine to inquire into the sincerity of the beliefs. It's just you've chosen not to.
The law allows that inquiry.
Okay, thank you.
Yes, I wanted to return, Judge Holmes, briefly. You had asked about leukemia, and I wanted to address that expressly. We are not in that same space. In that instance, the policy at issue was promulgated after the Church of Santeria indicated that they intended to open a facility in Hialeah. Promptly thereafter, the city promulgated this policy and included express language that was both connotatively and denotatively religious in making restrictions, focusing upon ritual and sacrifice. Not so with the September 24th policy. CU does not target religious conduct for distinctive treatment in a manner that does not advance its governmental interest. It does not advance its governmental interest only against those with a religious motivation.
I am finding this argument incredibly interesting, but given my generosity, I think it's going to have to come to a conclusion soon, because I'm going to give counsel a little bit of rebuttal time. So if there's anything remaining that you're burning to tell me, tell the court, then tell us. Otherwise, please conclude.
Thank you, Your Honor. You've been very gracious. Because the university's September 24th policy furthers the university's legitimate governmental interests and is both neutral and generally applicable, it readily passes the Smith National Basis Review. Therefore, the university respectfully requests that this court affirm the district court's denial of the first preliminary injunction as moot, and likewise affirm the district court's denial of the second preliminary injunction for want of failure to satisfy the four-part test predicate to the issuance of the extraordinary relief that plaintiffs seek. Thank you.
Thank you. Let's go with 3 minutes. And it will be a hard 3 minutes.
Thank you, Your Honor. So the government can take into consideration sincerity, but it cannot consider legitimacy. As Masterpiece Cake Shop said, the government may not presume the illegitimacy of one's religious beliefs, but that's exactly what happened under the September 1st policy. And looking at the evidence in its totality, and I'd point you to the New Hope Family Services decision in the Second Circuit, which had actually undertook a similar analysis. There it was a motion to dismiss stage, but the court reversed a grant of motion to dismiss, and the district court then applied the same analysis to grant a preliminary injunction of finding non-neutrality based on the facts and circumstances. Also, failure to disavow. So the government here still fails to disavow the express presumptive illegitimacy they undertook under the September 1st policy. So Masterpiece Cake Shop said the Civil Rights Commissioner's failure to disavow, and even the government's arguments in their briefs, failure to disavow their initial overt discrimination was evidence of suspicion that there was something more afoot here than just, Jack Phillips' supposed discrimination. There was a hostility towards his religion, and even distrust triggers the heightened scrutiny.
And so we're talking Lukumi in framing this argument,
correct,
right? Okay.
Correct, Lukumi. Also, I'd say Masterpiece. Also in Axe and Flynn, this court's decision in Axe and Flynn, there was a neutral rule. You've got to adhere to the script. And the Mormon student said, I do not want to take God's name in vain. I don't want to say some cuss words, not all cuss words, but some. And this court, granted, it was summary judgment stage, but it said that that's evidence that raises concern and requires an analysis of whether there's something more than the stated interests. And we have here, it can't be overstated how important the initial September 1st policy is to the analysis. The discrimination was overt. This is an extremely unique case. They put the discrimination in writing, and then they applied it perniciously. They sent out this mass August 26th email, impersonal, by the Vaccine Verify, anonymous, no one knows who they are, there was no accountability, you only had 5 days to comply, no opportunity to appeal. They told John Doe 1 that the university had discovered some unrelated Buddhist university that allegedly had inconsistent beliefs with his Buddhist beliefs. Jane Doe one, they said, "We sincerely hope you reconsider your beliefs." That's in Masterpiece Cake Shop and in Axum Flynn. The government officials expressly wanted the individuals to reevaluate their values or compromise on their values. That was evidence of something more than just a neutral policy. We have that in spades here. Also, the idea that they accommodated the remote workers. Title VII, just by analogy, says you can't even segregate employees in a way that would even tend to deprive them of employment opportunities based on their religion. So the remote employees here are seeking more than that, but just also, those employees were already put in remote positions under the September 1st policy. Chancellor Elliman said that some work was rendered remote under the September 1st policy for business continuity purposes, and it would be for the foreseeable future. Nothing changed, and certainly the in-person care employees are similarly situated to the in-person work that the university already allows at affiliate and non-affiliate sites. So we ask this court to reverse the district court and remand with instructions to grant a preliminary injunction. Thank you.
Thank you for the fine arguments. Case is submitted. Next case this morning is 22-1004. Okay, doors closed. Counsel for appellant, if you would make your appearance and proceed, please.
Good morning, Your Honors, and may it please the court. My name is Adam Goodman. I'm a standing Chapter 13 trustee for the District of Colorado, the standing Chapter 13 trustee for the District of Wyoming, and I'm the appellant in this matter. With me today is my staff attorney, Jennifer Cruz Turner. The question before the court today is whether the standing Chapter 13 trustee retains the fee collected under 28 U.S.C. 586 E2 if the debtor does not obtain plan confirmation. I'm asking this court to reverse the district court, affirm the bankruptcy court's decision, and answer yes, the trustee retains the statutory fee. There are no factual disputes. This is an issue on a conclusion of law and statutory interpretation that provides for de novo review. Congress established bankruptcy trustees as individuals who are not employed by the federal government and do not receive any funding from the government. With that in mind, Chapter 13 was created by Congress as a pay-as-you-go system. As one court described it, the Chapter 13 trustee's fee is a user's fee, and the debtor is the user. Section 586, which is separate from the Bankruptcy Code, executes this congressional intent. Now, there are not many cases on this issue, and this is a matter of first impression at the circuit court. There's also 2 other circuit court cases pending. The Sousis matter is pending before the Second Circuit, and the Evans matter is pending before the Ninth Circuit. In both of these cases, the Chapter 13 trustee is the appellee. There was also another recent case, Harmon, that was concluded at the Ninth Circuit BAP, also in favor of the Chapter 13 trustee. Now, 586 is the only provision that specifically addresses the standing trustee's right to the statutory fee, and it speaks in absolute terms. 1326 under Title 11 coexists, and it does not conflict with 586. There are those who will compare 1226 and 1194 to 1226 and look at differing language. I would submit that those are pointless analogies from administratively different bankruptcy chapters and a negative inference.
Well, you say 1326 doesn't conflict, but it does say that if a plan is not confirmed, the trustee shall return any payments not previously paid. That seems to be a policy of returning things back So it does seem to me that that is kind of conflicting to your position here, isn't it?
I don't see that as so, Your Honor. When I look at 1326, I believe that provision is creditor-focused. A trustee is not a creditor. A standing trustee is not an administrative claimant. Under the first sentence, it speaks about the trustee retaining payments that are proposed by the plan. Now, the trustee's fee is not a proposal. It is not a choice. When I look at 1322 and 1325, which are the permissive and mandatory provisions for Chapter 13 plan confirmation, there's no reference to the trustee's fee. And there are cases that go back to the 80s and 90s where the trustee's fee cannot be modified. There are debtors who have asked for the court to adjust the fee, and the courts have decided they do not have the authority, the authority rests with the United States trustee, who is the overseer of the Chapter 13 trustee system. And so
That's a different question than modification rather than payment. I mean, you do have this language in 1326, if a plan is not confirmed, the trustee shall return any payments not previously paid and not yet due and owing to the debtor. I know that it's not a direct control, but in a case with so many conflicting arguments and so many conflicting policies, I mean, this case can make your head swim because you can make cases on both sides, and you both have done so very admirably. But isn't that at least a beacon for us to hang our hat on?
Well, as I look at it first, Judge, I would first step back to 586, and it speaks to the standing trustee shall collect the percentage fee from all payments received. So we're starting off with the concept that we're not talking about dispersing funds, but the trustee receiving those funds.
Well, but collect is not necessarily self-evident what that means. Collect can mean collect and hold. And if it means collect and hold, then it could mean at a certain point, if there's not confirmation, you return that money.
That could be, Your Honor. However, hold is not part of the statute. And in fact, as it says, not previously paid under 1326, the trustee had already previously been paid. And so as I look at 1326 and I look at the creditor focus, it talks about under that second and third sentence of 1326A2 that it's funds not previously paid, that's already been paid to the trustee, and
Paid
funds
in the
not
sense
yet
of
due and owing.
delivered to the trustee. I mean, these terms, the problem here is they're amenable to different interpretations. I mean, paid could mean I'm paying you until a time certain. And that time certain is confirmation, non-confirmation. And then at that point, there's some determination to be made. I mean, if you're looking at 586E, I take it your view is that it's unambiguous in what it's saying, correct?
That is correct, Your Honor.
Well, don't you also rely in your argument somewhere on BTD Farms, where BTD Farms says that that provision is ambiguous? And how do you square those two?
The way I would square it, Your Honor, is that BDT Farms dealt with the fee-on-fee issue, which is a separate issue than what's at stake before this court. This is a matter...
I didn't understand you. You got a little bit soft there. Speak kind of into the microphone a little bit more loudly. Just repeat that last sentence.
As I saw it, Your Honor, the BDT Farms is a case that involved a fee-on-fee issue and is a separate issue. And when one looks at the statute, you may not easily see, and as this court found, there was ambiguity in 586 in relation to looking at that issue. This issue says that the standing trustee shall collect a percentage fee from all payments received. And so I see that as a different issue than what BDT Farms addressed.
Well, it is a different issue. The question becomes whether the statute is any more amenable to a clear, unambiguous interpretation in this instance than it was in BTD Farms. And if that's your position, then why don't you jettison BTD Farms entirely? You do rely upon it elsewhere in your brief, right?
I certainly cite that, Your Honor. The Bankruptcy Court had determined that it viewed the issue as similar based upon 1326 and the references to whether or not the fee is part of the plan or is it not part of the plan.
And let's talk about those statutory analogies. I mean, I think you suggested that they were poor analogies, and it's not entirely clear to me why that is. I mean, they deal with the same general subject matter, and two statutes say that speak specifically to the question of whether the trustee can retain the money. This one doesn't. And to put a finer point on it before I hear your response, there was, looking at the statutory history, and I'm not talking legislative history, I'm talking sort of the evolution of these statutes. Congress at a certain point had occasion to do 1226A, and at that point they amended a part of 1326. Now, when they did 1226A, creating this provision that says that the trustee can retain the funds, well, they had an opportunity when they were tinkering with 1326 to do the same thing. They didn't do that. And so, I mean, if we're trying to draw inferences from the structure of the statute, from the evolution of statute, from what Congress did, why isn't that, well, number one, why isn't just looking at the comparison of the statutes compelling? And two, what import can we derive from this statutory history that I just outlined?
Well, Your Honor, certainly Chapter 13 has been around much longer than Chapter 12 and Subchapter 5. And I don't know that we can necessarily draw an inference as to the fact that one chapter says one thing, that it should say the identical thing in another. That may not have been an issue they were looking at, and I don't believe
Well,
other
that goes exactly to my second point. My second point was there was an occasion in when Congress did 1226A, the provision I think that we're talking about here, they also tinkered with 1326. So they went back and revisited that same statute. So right in front of them is trustee gets to retain the money. Right in front of them is this other provision that at least on its face could suggest that the trustee has to return the money. Well, Congress had plenty of opportunity to change the latter, and it didn't do that. So my second question is, why isn't that in some sense suggested that Congress didn't intend to do that?
Well, Your Honor, when I first look at the applicability provisions of Title 11. And 103, H, I, and J, each in their own basically say that you stay within the chapter you're in, and that you don't look at other chapters to determine how to interpret your particular chapter that you're operating under. So it's not a mix and match situation.
I thought that I read it recently, and I thought DT Farms specifically had a footnote that said you can look to Chapter 12 in construing Chapter 13, well, construing the provision 586E there. Well, that's not in the same box. It's not in the same title. So why not?
Well, Your Honor, when I look at 1226, 1326, and 1194, each of them uses separate language. They are not identical languages between any of them. And when I look at the chapters themselves, each of those three chapters have different eligibility requirements. Each of them have different plan filing requirements. For example, in Chapter 13, the debtor has 14 days to file their Chapter 13 plan. They have 30 days to start making their payments monthly to the Chapter 13 trustee.
Well, those are differences, but do they go? I mean, you can talk about there. Obviously, there's tons of difference, but those don't matter to us. The question is, are there differences about whether trustees can retain funds when the plan or the objectives fail?
Well, as I also look at it, Your Honor, under 1326, it uses language that the other chapters do not use. It speaks of funds not previously paid and funds not yet due and owing to creditors. Those phrases are not used in Chapter 11. They are not used in Chapter 12. Each chapter has its own language to effectuate the results that are virtually identical to them, that the standing Chapter 13 trustee is paid.
Well, I found the language my brain was looking for. Footnote 3 of that BTD Farms, Chapter 12 was closely modeled after Chapter 13. Well, okay, well, they're closely modeled after each other. And at some level, yes, there may be additional language, but the point is, as it relates to the specific transaction that we're talking about here, what we know from Chapter 12, what we know from Chapter 11, that provision, is that Congress knows about this, they recognize this as an issue, and they provided for it expressly. So it seems to me that raises the question, yes, under the negative inference canon, why we can't infer that Congress knew about the issue and just decided they didn't want to fix it in Chapter 13.
I would submit that it is appropriate to treat all chapters similarly, and that the trustee should be.
Well, is it really appropriate? I mean, don't we have under Chapter 13 kind of a different situation of trustees without really reserves, and they really, this is kind of a Hail Mary last choice. Aren't they really positioned differently?
Your Honor, the Chapter 13 trusteeships, in each of them are different, function based upon receiving funds from the cases that they administer. And the debtor makes monthly payments in each instance. And the Chapter 13 trusteeship is a self-funded system. As I stated before, there are no government funds involved. And those who use the system have to pay to use that system. And it doesn't properly operate if all parties who use the system do not pay for it. You know, when we look back to the word collect, Judge Holmes, I look at it similar to this court collecting a filing fee, or when the shopkeeper collects taxes.
I'm not involved in collecting the filing fees, so I don't know. Go ahead.
But I mean, it's the same concept, Your Honor, that something is being collected. And I think that is more of an absolute issue. The statute does speak to shall, and it speaks to shall even in 1326. And to step back a moment, under 1326B, it also speaks to the standing Chapter 13 trustee. It speaks of 586 again. Two references that you will not find in Chapter 11 or Chapter 12 when it comes to compensating the trustee. So the languages are different, but they end up reaching the same result.
But that just presumes a meaning of collect, which is not necessarily self-evident. Let me just move on for a second. What's your view of Chevron deference in this context? Were there some discerning of ambiguity here?
I think if there is ambiguity, that you know, as it is in Chevron, you look to first if it's ambiguous. If it is, then you look to whether the agency's construction is permissible. And when I look at the United States Trustees Handbook on this issue, it is consistent with one interpretation here. There's nothing arbitrary or capricious. It is not manifestly contrary to the statute. The concept is that under 586, the United States trustee is the only party that oversees the standing Chapter 13 trustee system. It is not with the court. It previously was with the court, but it was separated in the 1980s so that the United States trustee was the party that oversees the entire operation of the standing Chapter 13 trustee.
But well, what do you do about the fact that the handbook is not the product of notice and comment rulemaking?
It doesn't have to be mandatory. It could be permissive deference to that agency. Everything
well,
within,
if it's permissive, it's not Chevron in that sense. Okay.
But in the same sense, Your Honor, since that is the agency that oversees the standing trustees, it would be appropriate to look to see how they would interpret the statute and have the trustees operate in that function.
But nothing that the handbook said cleared the kinds of scrutiny that happens when agencies adopt regulations and they have public notice and public disclosure. I mean, a handbook is just something that they write up and then can change. So it has much less reason to be given deference. Don't you agree?
That could be the case, Your Honor, but I think it is a solid piece of information that helps the trustees operate and properly function and causes the system to function the way it should.
It simply tells us what the trustees' position is, but we can tell that from the argument today, and we can also tell it from their self-interest. They would like to be able to retain funds. So, I mean, nothing there is surprising whatsoever.
Well, the United States trustee, unless the trustee collects too much funds, which is never the goal, the standing Chapter 13 trustees' goal is always to keep the fee down. And that's one of the problems here is if everyone does not participate and pay in the system that they go into, then the folks who are completing their plans and getting their cases confirmed are the ones who are paying for the system for those who do not get their cases confirmed. And in this situation, we're looking at a debtor who is self-employed, who enjoyed the automatic stay for over 2 years, filed 4 plans, did not amend his income or expense schedules. The standing Chapter 13 trustee has a duty to be heard at confirmation, and the bankruptcy court sustained my office's objections. The bankruptcy court found that there were significant inaccuracies, there were material miscalculations that were neither illusory nor speculative. In fact, based upon the bankruptcy court's findings, essentially over a 5-year period, this debtor would have shielded over $112,000 for payments to creditors. Debtor's counsel was paid, and the debtor is seeking to disgorge the fees my office has received in this case of less than $2,600. What the debtor is seeking to do here in this case is create a financial conflict of interest for the standing trustee where confirmation becomes a carrot and forces the trustee to put aside his duties and responsibilities to allow a case to be confirmed that should not be. This is a perfect example of that situation. This case did not deserve to be confirmed the way the debtor performed here. The debtor wanted my office to ignore the debtor's finances, ignore the debtor's known inaccuracies, ignore the debtor's duties and responsibilities, cause my office to ignore and put its responsibilities aside so that the debtor can have a plan confirmed.
As you pointed out, this is a case of statutory interpretation.
Indeed.
We're not here to punish this debtor.
I'm
And-
pointing
and,
out.
We'll give you some rebuttal time.
Okay,
Let's
thank you, Your
conclude
Honor.
right now. Thank you.
All right.
Morning. Morning, Your Honors. Steve Birkin on behalf of the appellee. I'm joined by my partner, Sean Cloyce, and the co-author of the briefs, Tom Mathewitz. May it please the court. I'm going to go off script just a little bit and respond to what the trustee's final argument was. And to my mind, it was an appeal as to policy. He's going down the policy path. The first 7 pages of his brief are all policy. I submit that the statute trumps policy. There's no reason to go to policy. If we feel sympathy for the trustee because he works hard and it's a self-funded program, et cetera, and we should throw him a bone, that's one way of going about it. But to my mind, there's no reason to deviate from the clear mandates of 586 and 1327. I'm going to start, if I could, with my best arguments. And if I don't say these, I'm going to hate myself tomorrow. Let me just toss these out real quickly. Congress knows how to pay a trustee when it wants to, clearly, and it doesn't want to pay a trustee in a 13 for a dismissed and unconfirmed case. 1226 gives us direction. 1194 gives us direction. So does 1326 by its omission and the negative inference of 1326, not repeating what 1194 and 1226 has, gives us direction. 1326, if a case is confirmed, the trustee is to promptly pay per the plan. When a case is not confirmed, the trustee is to return those monies to the debtor subject to 503, which is administrative expenses, and the trustee doesn't fall under 503. My second strongest argument, I think, is the code is replete with the term under the plan, under the plan, under the plan. I was here about a year and a half ago in a case called Kinney. Didn't go well for Ms. Kinney, but ironically, it does weigh in this case. Kinney says, and so does Piccadilly from the Supreme Court, under the plan means a confirmed plan. It doesn't mean a proposed plan. It doesn't mean a plan that we're thinking of filing. It means an order of confirmation. This is why 586 goes against the trustee's argument. 586 uses the same term, under the plan. The trustee would have this panel believe that 586 stands for the proposition that as soon as you get the money, you get to keep it. It goes in your pocket. And to my mind, that's quite a stretch. Some of the cases that go against us.
Why is that such a stretch? I mean, collect could just mean that. You collect the money.
Right. Collect means collect and hold. It doesn't say that.
It doesn't say hold either.
It doesn't
says
say hold.
collect.
It doesn't. We have to look at the context. First of all, we've got 1226 and 1194 that says return the monies except for the trustee gets to pay itself. So 1326 doesn't help. The definition of 586, in some of the cases, they run to Black's dictionaries, et cetera. They don't look at the context of the big picture. Collect does not mean to sever a portion from each payment and then to put it in your pocket immediately. You keep the money at the direction of the order of confirmation, and that's what under the plan means. And if we don't have an order of confirmation, then 1326 gives us direction, and it says the money goes back to the debtor subject to 503. Another point, 586 is parked within Title 28, which is entitled Judiciary and Judicial Procedure. 586 in particular is duties and supervision. You contrast that to Title 11, which is the Bankruptcy Code, and then we look at 1326 called payments. Now, if we're talking about where should payments go, I submit, and not at the expense and the risk of sounding glib, let's look at the section that says payments. Let's not look at the section that says judiciary and judicial procedure and duties and supervision. 586 does really one thing. It says the percentage of the fee that the trustee is entitled to get. That's it. It actually goes on to say under the plan. So there we have that Kinney-Piccadilly result.
What did we do with, you referenced an argument that's at play in this case about the comparison of Title 12 and Title 11 in what they provide and what is not provided for in 1326. One of the arguments of opposing counsel is that this is really a sort of mismatch analogy because the language is different. Now, in 1326, we speak of payments. In 1226, we speak of payments and funds. What should we take from that in terms of whether 1226 is really applicable here at all? And I think that same language is in 1194 as well.
Sure. It's interesting, that raises several points. One, some of the case law suggests that the difference between the 13, the 12, and the 11 is that the 13 is fast-tracked. You file a plan within 14 days. There's a quick or confirmation hearing. 11 and 12 don't have the same. They take longer to get to fruition, if at all. So I think the enticement is for the trustees in 11 and 12, it's quite possible you're not going to get paid, and you're not going to get paid for quite some time, whereas a 13 is an expedited system. And therefore, if it's expedited, then the likelihood the trustee is going to be compensated is greater than in an 11 and a 12. This is just kind of dicta, and I think Judge Lafferty brings it up in his dissent in Harmon. Interesting, the use of the word funds, and I thought about that. Why put in the word funds? I can only guess. Chapter 12s and 11s often deal with the sale of property, the sale of the farm, the sale of real estate, the sale of something. It's quite possible that the plan payments and funds, you don't have funds so much in a Chapter 13 because you're not liquidating usually, you're reorganizing. But in 11 and 12, it's quite possible that you're selling something, then money's coming in from a third party. That I would consider to be funds.
So I take it from all this that your position would be even if funds had a practical import in the connection with 11 and 12, that does not change the fact that the difference that is reflected in 12 and 11 from what is in 13 is a distinction with a difference. In other words, Congress, it tells us that Congress intended to leave 13 as a vehicle where the trustee couldn't keep the money. In other words, the analogy is still a good one.
Exactly, Judge Holmes.
All right.
And I would also submit, actually, that thought just went out of my head.
Well, I suppose also if 13 is a factor proceeding, one could conclude that the attorneys, if they don't get their fees, that may be less consequential on average than in an 11 or 12, because it's been a quick in and out, and there may not have so much of an invested fee in the first place. So it might be not quite so consequential. Is that a fair thought as well or not?
I do think that's a fair observation, Judge Ebell. And also, I don't think we should look at legislative history unless there's ambiguity. I don't think there's ambiguity with 586 and reconciling with 1326, and I refer to Ron Pair decision from the Supreme Court. Let's get these statutes to reconcile one another. Let's not try to create conflict where there is no conflict. 586 works very well with 1326. 586, you collect the money. 1326, this is how you disperse it. Here's the legislative history on 586, very telling. If a private standing trustee serves, his fee is fixed by the Attorney General per 28 U.S.C. 586, and it will be payable under proposed 11 U.S.C. 1326 A2. It will be payable under proposed 1326 A2. Congress knew what it was doing. This goes back to 1977 when it promulgated this. And this argument that, well...
I thought you were just telling us that we shouldn't look at legislative history.
I know, and I deviated from my own rule.
I think so.
Yes.
All
so
right.
we can strike that. This business about, well, 1326 was promulgated at a different time than 1226 and 1194. Maybe it was an oversight by Congress. Really? I mean, are we going to go down that path? You know, we can say a lot of things about Congress, but one I don't think attributable to Congress is it forgot to amend 1326 to give some direction. It does give direction.
Could you shed some light on one, what appears to be sort of a, well, it may not be a factual oddity, but it struck me as one in this case, which is that in a number of these cases that have dealt with similar issues, there seemed to be the contemplation that payments would not come from to creditors until actually confirmation had taken place. In other words, that's when the decision would be made to return everything, and the decision point that's at issue here, whether the trustee would keep their share or not. Well, in this case, there were some payments made to creditors prior to confirmation. What, specifically Colorado Department of Revenue, didn't the Colorado Department of Revenue get some money? And if that's so, I just wanted some light shed on how does that work. I mean, well, how is that appropriate here where it doesn't seem to be appropriate, or it doesn't seem to have happened in some of the other cases?
Judge Holmes, I'm using memory, but I think the Colorado Department of Revenue got money under a distraint order post-dismissal. I don't think it ever got paid per an order of confirmation, because confirmation never occurred.
Well, not per confirmation. Prior to confirmation, there, it seemed to me that, at least my recollection of reading the materials was that there had been payments made to the, they used the phrase priority tax claim.
Right.
And that then the decision point came, do I return the rest of it plus my share, or do I keep it? I mean, if you don't have any recollection of that at the moment, that's fine. I don't want to belabor it, but it just struck me as an odd thing.
Right. I do remember the word distraint, and it's not uncommon when a Chapter 13 is dismissed, the government comes in, sends in a warrant, a distraint, and says, we're entitled to some of that money, notwithstanding the fact that 1326 says it should go to the debtor. So I don't think the government got paid prior to confirmation. You know, going back to the order of confirmation, the case law suggests that you cannot do anything without the authority of an order of confirmation. The trustee argues, well, Kinney only says when the plan ends, it doesn't say when it begins. But I say that's immaterial. We don't care when it begins. Maybe the plan payments begin 30 days from the order for relief or the conversion. It doesn't matter. We do know when it's confirmed. That's the key date. And without an order of confirmation, there's no direction until you get to 1326, which says that money goes back to the debtor subject to administrative expenses. Does the panel have any additional questions or concerns for the appellee? Once again, the only way the trustee is going to prevail is under policy. 586 doesn't help them, and as I said, the idea that Congress forgot to amend it is complete folly. Here's the big picture with Chapter 13s. Clearly, Congress prefers 13s. You can see that in 1328. You can see that in the means test. It pushes debtors since BAP CPA in 2005 towards 13s. Congress wants these cases confirmed. A confirmation order benefits everybody, not just the debtor, but the taxing authorities, the mortgage lender, the unsecured, the secured credit. Everybody is benefited from an order of confirmation. No one has benefited from an order of dismissal. And in this case, filing 4 objections to confirmation based on disposable income for a guy who repairs forklifts. And I know I don't want to get mired into the particular facts in this case, but the policy is, let's get these cases confirmed. It's a benefit to everybody. And the carrot is you get paid. The stick is you don't.
Well, that your argument confirms what I understood to be counsel's opposing perverse incentive from adopting your view, which is it allows for this for the carrot of getting paid to skew the system such that the trustee overlooks things that they otherwise wouldn't overlook, right?
It's possible.
It's possible.
It's quite possible. But why deviate from the clearer language of the statute and get into some policy
That's what we're
argument?
talking about to begin with, the clear language of the statute, right?
Sure.
Okay.
Well, I mean, if we're going to speculate that they may get paid for something they shouldn't get paid for, the other speculation is that they will be more highly motivated to get that plan confirmed.
That would be the carrot.
Which is the objective. That'd be the carrot. So, I mean, you know, that's why I said earlier, and we both said earlier, that you can find something for everybody in this case.
The cases are certainly split all over the place. Ironically, and I think the majority of cases are on our side, but I think the best analysis is the dissent by Judge Lafferty in the Harmon decision out of the BAP Ninth Circuit. He takes to task all of the minorities' arguments, and he addresses policy, and he addresses the definition of collect, et cetera. I also like the opinion because Judge Lafferty went to my law school. I wanted to point that out.
Thank you for doing so.
Yes,
Anything further?
I have nothing else, Your Honor.
Thank you, counsel.
Thank you for hearing me.
1 minute.
Thank you, Judge. I appreciate the time. As counsel, I believe, has proved my point in many ways, And I would just look to the court to look at Judge Romero's order denying confirmation to explain a lot of this case, why Chapter 13 is not a quick and out solution in many situations. I would desire it to be, but it not always is. And the trustee's duty is to keep an eye on these cases. And I think what we're looking at in this case is something that'll do the exact opposite if the court rules against my position. Now, we look at the statutory construction. I think we need to give each word its plain meaning. 586 in this situation, I believe, is plain meaning. We need to give effect to all provisions. I believe that looking at the way that the trustee looks at it in this case gives meaning to 1326, gives meaning to 586. We need to avoid surplusage and stick to clear language. 586 speaks in shall terms. 1326 speaks in shall terms. We should look at them together. Look at specific over general. 586 speaks very specifically. We need to avoid conflict, avoid absurdity. Debtor's counsel has established absurdity in the things he has talked about in regards to the situation. We do not add words to the statute. I would note that this is not a majority situation as the debtor would look at it. I believe that what we're looking at is a situation, unless you're in New Mexico, Toledo, Ohio, or Arkansas, trustees across this country are receiving the fee. I have a lot more to say, but I appreciate the time you've given me, Judge.
Thank you, counsel. Case is submitted. Thank you for the fine arguments. As one brief housekeeping note, while counsel are exiting, and for Judge Ebel as well, after this case, Bradford, we'll take a 10-minute break and then finish hearing the rest of the cases on the docket today. With that said, counsel for appellant in 22-1024 Bradford versus U.S. Department of Labor. Counsel for appellant, if you make your appearance and proceed, please. Thank you, Your Honor.
Good morning, and may it please the court. Caleb Kruckenberg on behalf of the appellants in this matter, Duke Bradford, Arkansas Valley Adventures, and the Colorado River Outfitters Association. Obtaining a permit to use federal lands is not an agreement to accept any future condition on all future activities that the government desires. My clients in this case operate river rafting services on federal lands, and they pay the government to obtain special use permits to do so. But those permits are very clear. They say that the outfitters, not the government, are the ones that provide services to the public. And in fact, those agreements even say that the outfitters shall not attempt to portray the activities as being conducted by the government. But the Department of Labor has now claimed the authority under the Federal Procurement Act to require those same outfitters to abide by a new minimum wage rule for all of their activities, even those that do not occur on federal lands. But the Procurement Act can't be stretched that far. And we have at least 3 different reasons why the rule is invalid. The first, and I think most obvious, is that the Procurement Act does not allow rulemaking concerning non-procurement activities that do not involve the federal government. The special use permits, as I discussed, they don't relate to the statutory elements of the Procurement Act for procuring and supplying non-personal services by the federal government. None of those conditions are present. Second, the rule is not necessary for an economic and efficient system of procurement. As a prior administration even recognized, when you use a wage rule like this against outfitters or against this segment of the population, it's not economical. It raises prices and it causes negative employment impacts for these same companies.
There are 2 things embedded in number 2. One, whose judgment is it what is economical and efficient? I mean, the way you expressed it, that would suggest your clients are making that judgment. That's not a judgment that's vested in them to make, is it?
No, and so when we're talking about economical and efficient procurement policy, it says necessary in the president's discretion. But I think what we have to look at is we have to look at the way the Supreme Court has instructed. We have to read those kind of terms. That's where I think the Alabama Association of Realtors case is very instructive here. That was a nearly identical statute. That said, the Secretary of Health and Human the Secretary, as the Secretary determined was necessary for health and safety. And the Supreme Court said that has to mean something, not just the Secretary thinks that, it has to objectively be true. And I think that kind of thinking
Objectively be true or objectively be a reasonable construction of what those terms could mean.
I think that's right.
Okay, well, the fact that the Trump administration had one view on economical and efficient doesn't mean that the current administration can't have their own view. And embedded, the second part, which I was going to get to, embedded in your statement was the notion that economical and efficient means price reduction. And I don't think the president has taken the view that it does mean that. And what is so self-evident that it has to mean that?
So there's two things, and I certainly agree with you, Your Honor, that President Trump's determination versus the current administration's determination, that doesn't present the answer. I mean, this is an answer for the court. But what it is good evidence, I think there's a strong disagreement, and I think what you can look at is the regulation itself, the evidence that's presented by the department, and when we look at it specifically with respect to outfitters and guides, which they call non-procurement contractors, they don't point to cost savings. They say this rule will actually negatively affect this segment of the population. It will raise prices. It will cause disemployment. They cite all of these negative things.
And they talk about morale and health
Right.
and all those things.
And that's what they try to offset.
That's what they try to process. Well, I mean, from a perspective of efficiency, if somebody shows up bright and sunny in the morning and has had a good night's sleep and has been well compensated, well, it's not, why is that an unreasonable, perhaps not the only one, but why is that not an unreasonable construction of it, what it means to create an efficient workforce?
Well, I think that goes to a line drawing question for the court. How much objective measurement do we have to include here? And we have to include something. It can't just be an intangible, we think employees might be happier. And I think if you look at the 6th Circuit and the 11th Circuit interpreting the same statute when they're dealing with vaccine mandates for federal contractors, they talk about these same kind of non-economic factors, morale, health and safety. And they talk about, and they say, both of those courts determined that is not what this statute is talking about. Because remember, this is a procurement system. That's what the economical and efficient is modifying. So it has to have some connection with obtaining services or obtaining supplies, procurement for the federal government. It can't just be in the downstream, this company will have morale impacts on their employees off-site, off of federal land.
Well, isn't it how the company provides services to people who are availing themselves of their services on federal land? I mean, part of the whole thing, right? Isn't it that the government is creating a structure of licensees who know are not providing government services, but the government has some obligation to make sure they're not running amok and doing things vis-a-vis the people they're serving, right? They're providing economical and efficient services.
Well, I mean, that goes back to the first question. Who's providing the services? It's the outfitters. It's not the government. And the idea that just as an overview matter, the government can say, we can still regulate how you're providing services, even off of federal lands, just because of the hook of this permit under the Procurement Act. I mean, I think, is just a stretch from the very beginning. And the government has said over and over again, we don't have to be a party to any of these.
Well, let me ask this question. As it relates to the line drawing, which I think appropriately does lie with us, you spoke about objective indicators, well, is the objective in this sense what is reasonably understood these terms to mean? I mean, you're not suggesting that we're in the numbers crunching business of determining what sort of added value comes from one regulatory scheme or another, because if that were the case, I think this is going to be very challenging for this judge to engage in that enterprise. I mean, this is not a numbers crunching enterprise, right?
No,
we're talking about
it's
the
not.
terms.
Right, and I think the two limits that the other courts have said is a close nexus to economy and efficiency to government savings. That's what they talk about. That's what Kahn talked about. That's what the 11th and 6th circuits have just reaffirmed. And they also talk about economic savings. So those are the two conditions here.
And how are those things measured? I mean, in what sense are we talking about? I mean, what are we going to be having some evidentiary presentation on you saved X dollar for what you provided? I mean, or is it some sort of commonsensical idea that there's, in general terms, by doing X, Y, and Z, you save money?
You look at the asserted benefit.
Yes.
And the Department of Labor, the asserted benefit for my clients is morale. And these other non-economic factors.
Morale, and if I recall correctly, you can correct me, please, if I'm wrong, but it was morale and also the health of the workforce. And I mean, and I mean that, particularly in the business that your clients are in, that's not an insignificant factor. I mean, if your employees are overworked and they're unhealthy as a consequence of that, or they aren't compensated such that they can take care of their health, that has downstream implications, does it not?
I'm not saying those are not important issues. That's just not contemplated by the Procurement Act. Because if you look at these same benefits, these same class of asserted benefits, I mean, these are almost verbatim to the ones considered by the 6th and the 11th Circuit in Kentucky and Georgia versus Biden. And the court in both cases said, as a class, categorically, that's not cost savings to the government as a system of procurement or supply. That's the problem here. It's just the wrong category of benefit. And the Department of Labor is asserting the wrong goal, and they're using the wrong statute to do that. And to the extent that it's unclear, we don't know what kind of line drawing we should do, I mean, that's where the major questions doctrine, I think, yields a very clear answer. Obviously, it is a part of this court's practice for years. It's also, the Supreme Court has made it very clear that in this kind of situation, this supplies the answer. If Congress was not very clear that this kind of act gave wage rules over non-procurement contractors, then we have to err on the side of disallowing the regulation. Okay, so the major, well, number one, we have to classify it as a major question. And so what is the question that we're talking about? Is this regulation of non-procurement permittees like your clients, or are we talking about a broader class of people? Well, the argument I am making specifically with respect to my client is non-procurement contractors. And that they classify, they form a major question, the regulation or not of those individuals. Well, for the major questions, we look at the rule itself. We look at what the rule does. But I mean, in order to this, we're in the line drawing business, and part of the line here is in defining major question. If I recall correctly, that goes towards the sort of broader, well, it goes towards the impact writ large of this regulatory step. Well, if that's true, and I think there was a figure like $1.7 billion talked about in this case, well, that related to all contractors. And therefore that creates a mismatch, because if we're talking about the major question being here related to the non-procurement permittees, what's the dollar figure attached to them?
And if that dollar figure is nowhere near this $1.7 billion, then it really sort of changes our view of whether this is really major or not, does it not?
What I would say to that is I think the initial question is, does the Procurement Act allow a wage rule against anyone? And I think there is a negative, that is not the case. I don't think that can be justifiable. But that's the major question.
Wage rule against anyone.
Well, against any procurement or non-procurement,
You know,
you can use this act.
May I interrupt just a minute? You've only got a minute and 50 seconds left. But I have real doubts about whether the Procurement Act applies because I'm not sure the government procures anything here. But I'd like to have you just spend 30 seconds on the government's implied powers argument that they have inherent power to regulate this kind of stuff. Just, you've got such little time now, just give me conclusions. I don't want to cross-examine you about it. I just want to hear 30 seconds of
Well, Your Honor, I would
argument.
I would just point to the DC Circuit's decision in Mendoza versus Perez and Allball, both of those. This is not a housekeeping rule for internal government administration. I mean, this very clearly has impacts far outside of internal agencies, including my clients, and there's testimony in the record. I think that is just a sort of a nonsensical argument to try to avoid the fact that this is very clearly a rule of general applicability. And Your Honors, I would like to reserve my remaining time for rebuttal if that's
Yes, that's fine.
Thank you, Your Honor.
May it please the court, Drew Ensign, Arizona Deputy Solicitor General for the Amici States. We appreciate the court.
May I start? You've only got 4 minutes, so what is your topic?
We're going to talk about major questions doctrine, and if there's time, the APA claims as well. This case is ultimately controlled by the major questions doctrine, particularly as refined by West Virginia v. EPA. The United States defense overwhelmingly relied on the proposition that no such doctrine existed at all, so much so that they put it in scare quotes all 3 times they referred to it. But West Virginia makes plain that such a doctrine does in fact exist, and that defendants' doubts and scorn were entirely unwarranted at the time, and now indeed are outright indefensible. The major questions doctrine demands clear congressional authorization for the power the agency claims, which is not even arguably present here. The central question thus becomes whether the authority to regulate wages for fully 1/5 of the U.S. workforce is a major question. And to ask that question is effectively to answer it. That is precisely the sort of issue of, quote, regulatory power over a significant portion of the American economy, end quote, that West Virginia makes plain is a major question.
1/5 of the workforce being defined as what? Who are we talking about?
That's ultimately the scope of, that's everyone that the federal government claims is within their power under the Federal Procurement Act. That's what the Sixth Circuit has estimated, that the scope of the regulatory power that's being asserted over, contractors ultimately affects.
Well, hence, and is that scope correlated with the $1.7 billion that we're talking about in this case?
No, Your Honor, but I think the actual major question under West Virginia is clear that it's the scope of the authority claim. So what West Virginia says is the relevant question is, quote, the breadth of the authority that the agency has asserted, end quote, and that's at 2608. Here, the source of the authority to regulate wages or to revoke the outdoor recreational exception is just yet another manifestation of defendants' asserted plenary power to regulate wages for 1/5 of the economy as long as they're willing to concurrently mouth the words efficiency and economy. That, there's nothing about the scope of the authority that they've asserted that wouldn't allow them to say, impose a $1,000 an hour minimum wage. And so,
well, is it West Virginia that determines that we are not looking at the scope of authority question as focusing on the non-procurement permittees? In other words, the clients of counsel party counsel in this case, are not the entire workforce, and they're not that full scope of the workforce that would be regulated. And so why aren't we just focused on that group of people?
I think because that's how West Virginia looks at it. It makes clear that it's the scope of the authority asserted and not how it's being exercised in the particular case.
All right.
So even if this were a rule that merely upped the wage from $10.30 to $10.40 an hour, it's still a major question because of the underlying authority that's being claimed, which is the authority to regulate wages for the fifth of the economy, essentially displacing Congress for 20% of the U.S. workforce. That is a major question. And everything here is a manifestation of that assertion of authority, and whether or not they possess such truly awesome power is indeed a major question. Turning to the APA issues, the rule is also independently invalid if the APA applies because the Department of Labor admits that it did not consider alternatives to a $15 an hour minimum wage or to not repealing the outdoor exception. That refusal plainly violates the APA because there's no just following orders exception to it. So the dispositive question is whether the APA applies, and the DC Circuit's decision in Chamber of Commerce makes clear that it does. It says that the existence of a presidential executive order hardly seems to insulate defendants' actions from judicial review under the APA. And the Ninth Circuit has gone even further than that, applying Chamber of Commerce to say agency regulations that implement an executive order are reviewable under the APA, end quote. That's 932 F3rd at 770. So there simply is no just following orders exception to the APA, and because that's the defense of the explicit refusal to consider alternatives here, the rule necessarily fails under the APA as well as for lack of statutory authority under the Procurement Act. And I see I'm out of time. I certainly welcome any questions, but
Thank you, counsel.
thank you, Your Honors.
Good morning, Your Honor. May it please the Court. Daniel Winnick for the federal government. The Federal Property and Administrative Services Act, or FPASA, confirms the President's authority to issue directives.
The microphone, please.
Your Honor. Confirms the President's authority to issue directives. Is that better? To executive branch
Better if you
agencies.
stay close.
Better? Okay, thank you.
Yes.
Let me start. The Federal Property and Administrative Services Act, or FPASA, confirms the President's authority to issue directives to executive branch agencies about the terms on which they should enter into contracts. In the order implemented by the rule challenged here, the President determined that the government should choose to contract only with companies that pay their employees at least $15 an hour for work performed on or in connection with a federal contract. And I need to correct a point made by Mr. Kruckenberg a couple of times on this issue. What is asserted here is not the power to set a minimum wage paid by any federal contractor for any work on or off federal lands. This is an order saying when you, a federal agency, enter into a new or renewed federal contract, you must do that only with a company that is willing to pay their workers $15 an hour for work on or in connection with the contract. If they don't want to renew a permit, that's fine. If they don't want to, they can pay their workers whatever they want for work off federal lands. This is a very, very narrow authority about the people with whom the federal government should choose to contract. That order carried forward a similar directive with a lower wage rate that had been in place since 2014 and through the entirety of the Trump administration. Now, plaintiffs fall into the small category of contractors who do not provide goods or services directly to the federal government, and their primary argument is that the President's authority under FPASA doesn't cover contractors like them. But that ignores the statutory text, which articulates the objective of the statute to include, quote, an economical and efficient system for procuring and supplying property and non-personal services and performing related functions.
What is the government procuring? That's what I'm confused about. What is the government procuring? The government isn't itself getting any guiding services. The government is merely enabling guiding services to be procured by other private individuals.
We certainly agree, Your Honor, the government, as to this particular group of contractors, the government's not procuring anything. What's at issue here is the word supplying. when a contractor provides goods or services,
The question what? What is the word you're talking about?
is supplying. So the statute says procuring and supplying property and
The
non-personal
government's not
services.
supplying, the government is not supplying anything either. I mean, I just have trouble with both of those words.
Your Honor, the government, we think, is supplying recreational services here in the following sense. The government,
They're not, when somebody wants to hire a guide, they're not going to the government and say, supply the guide to me, please. They're going right to the guide.
very much agreed, Your Honor, but the statute refers to a system for, among other things, supplying non-personal services. So the way we think about it is this. These are federal lands. The federal government has an interest in people being able to recreate on these lands and in people who provide recreational services complying with terms.
Well, there's no doubt the federal government has an interest. I don't doubt that at all. But my question is, I just have trouble applying the Procurement Act here, period. Because I don't think they supply services, and I don't think they procure services.
So, Your Honor, the reason we think this is it's natural to think the government supplying services here is if you start from the premise that these are federal lands, the government wants people to be able to use these lands, it has various choices about how it's going to go about doing it. It could supply those services by having federal employees lead rafting trips, or it could choose to do what it's done here, which is say, we're going to enter into agreements with private companies who will pay us a share of their revenues in exchange for the privilege to lead rafting trips on these lands. The government has made the second choice. That doesn't change the fact that what the government is doing here, that this is a system for supplying non-personal services, even if the government, by virtue of the choice I just described, is not the one leading the raft trips. And, you know, I think the key point, Your Honor, is that under...
Well, the government is not supplying rafting services. The government is allowing other private people to supply them. So you are saying, I guess, that means the government indirectly is supplying those services.
That's right, Your Honor, and...
The government is enabling their supply.
Yes, with the key point, Your Honor, that this is federal land. So it's not that anytime the government enables anybody to do anything, the government is sort of doing it or supplying it. I think it's just crucial to regard this within the context of this is federal land. The federal government has a system for making these services available on the federal land, and this is the way they've chosen to do it, as opposed to by providing those services themselves. And crucially, under plaintiff's view, the word supplying doesn't have any meaning. Plaintiff's view is this statute is limited to contractors who provide goods or services directly to the federal government, but that's procuring. The plaintiffs have no satisfactory explanation of what the word supplying means under their view of the statute. Every example they give proves the point. They say, you know, for example, if the federal government runs a campground and it hires somebody to, you know, help it run the campground, to provide food services or clean the latrines or something, that's, you know, supplying. But what the federal government is doing in that example is it's paying that company, it's procuring that company's services to do the cooking or the cleaning or whatever else. There's just no example, there's no real world example of the government supplying something that would be considered non-personal services under this statute. So that's why I'll grant that this isn't necessarily the first thing you would think of. If you said what's happening here, you wouldn't necessarily say that the government's supplying these rafting services, but we do think it's the most sensible interpretation of the statute, given that plaintiff's alternative interpretation would render the word supplying surplusage. And just
What is, I didn't catch your response to the idea here anyway, your response to the idea that this affects federal land, that this is federal, that this is not just limited to what plaintiffs do vis-a-vis their employees on federal land, but it extends to the government's effort to regulate their relationship with their employees even off federal land.
with respect, Your Honor, it's just not right. I mean, this rule tells federal agencies when you have new or renewed contracts, you must include in those contracts a clause that says the contractor must pay their employees $15 an hour for work performed on or in connection with the federal contract. Now, as to federal land, the person who's at AVA's headquarters taking reservations is performing work in connection with a federal contract. And if that person does it for more than 20% of their time under this rule, that they must be paid, $15 an hour for those hours. But they don't have to be paid $15 an hour for the work they spend, for the time they spend booking other trips. And certainly any guide employed by
Counsel,
ABA.
I don't know, I'm sorry, but how is that realistic? How would you pay the raft guides $15 an hour? Are you suggesting while they're in the part of the river that is covered by federal land, and then when they're not on federal land, they can pay anything that they want or within other laws? I am not sure how you're parsing that.
So, Your Honor, there may be some tricky application scenarios. I don't think they're presented here. I think AVA's trips that we're talking about, the ones covered by this permit, are all sort of on the Eagle River within BLM land. Possibly I'm wrong about that. But as a matter of concept, nothing is being regulated here, first of all. This is an exercise of proprietary authority. But it's telling federal agencies, when you enter into these permits, do it only with companies that are willing to pay their employees $15 an hour for work on or in connection with the federal contract.
What if a contractor says, okay, we're willing to pay $15 an hour for that stretch of the river on federal land, but the stretch off the federal land, we're not going to pay $15 an hour. This is apropos of Judge Hyde's comment, which I'm intrigued about. Would that pass muster or not?
Your Honor, I actually don't know the answer to the question about how the Department of Labor, in applying this rule, would think about that exact scenario, a raft trip partly on federal land and partly not. But in terms of the assertion of authority here, in terms of what this rule does, this is absolutely not an exercise. It's not an exercise of regulatory power, period. It's certainly not, as plaintiff's counsel described it, an exercise of the power to regulate, a fifth of the federal economy, whether or not.
In any event, you earlier said, I think that these contractors, there's no indication, or that there is affirmative indication maybe that their permits and their rafting would be entirely on federal land. So that's a question for a different day. Is that right? Or will we discover in the record that this only involves rafting trips entirely on federal land? So we don't need to address the other issue today?
I mean, certainly AVA leads lots of different trips on and off federal land. I think that as to the question whether the particular, we're talking here, the permit that they had to renew in March 2022, the one that contains this, well, I guess it doesn't contain this provision because the enforcement of the rule was enjoined pending this appeal, so I don't think they have any contract actually that contains this provision, but that was the basis of their standing. And so as to whether the trips they conduct on the Eagle River also, go on non-BLM land, I just don't know the answer to. Plaintiff's counsel may. But in terms of the assertion of authority here, in terms of what this rule does, this is an assertion of authority limited to entering into contracts with companies that are willing to pay workers $15 an hour for work on or in connection with the federal contract. It's much more limited than plaintiff's counsel or their amici have suggested.
Well, what about amici's suggestion that it does relate to 1/5 of the workforce, and that at play here is the scope of the asserted authority, the authority to regulate and impose, essentially require in contractual relationships the imposition of a minimum wage. Why isn't that correct here?
So, Your Honor, I think the major questions doctrine doesn't shed light on this case for several different reasons before you even get to the question of how big is this rule.
Before you get to those several questions, answer that specific question so that it's clear to me what the answer is to that.
Well, Your Honor, I think the answer to the several questions is this case just doesn't implicate a question about what would happen if an agency tried to regulate the wages of 1/5 of the U.S. economy. The basic reason the major questions doctrine is inapplicable is that that's a doctrine about assertions of regulatory power with vast economic effects. This isn't an assertion of regulatory power at all. This is a directive to federal agencies that when they are entering into contracts, they should do it with companies that are willing to pay a minimum wage, not do it with companies that are not. That's not an exercise of regulatory power.
Why is it not, since DOL issued a regulation, did it not, to implement that directive?
It may be called a regulation, but, Your Honor, there is a distinction between regulatory and proprietary authority. If you look at Perkins versus Lukens Coal, the Supreme Court's decision addressing the Public Contracts Act, which requires the payment of prevailing wage to certain contractors, the Supreme Court said that did not represent an exercise by Congress of regulatory power because, quote, Congress did no more than instruct its agents to fix the terms and conditions under which the government will permit goods to be sold to it. It's really a crucial distinction. There's also not, this is not an assertion of power based on a cryptic delegation of authority. The terms of the Procurement Act, the delegation of power to the president to prescribe policies and directives is quite broad on its face. There's no concern about political accountability when delegating authority to the president himself. The statute is bolstering inherent constitutional powers of the president. And that all brings us then to the question of whether this is even if all of that weren't true, whether the matter before the court is one of vast economic or political significance. Whatever amici may want to say about sort of how broad a directive could be, what effects it could have, this rule, even if you consider the rule as a whole, as opposed to just its application to non-procurement contractors, much less its application to wilderness recreational providers, the agency expected that only 1/5% of the U.S. workforce would see increased wages under the contract provisions required by this executive order. 1/5% of the U.S. workforce. That's by comparison with, the recent Supreme Court decision about the OSHA vaccine or test rule, which was going to affect more than half the U.S. workforce. I mean, this is far, far from anything the Supreme Court has regarded as a major, as an exercise of regulatory authority, with vast economic or political effects.
Is that same reasoning as it relates to this not being an exercise of regulatory authority, does that same reasoning bleed into why there is not an APA problem here relative to the DOL's promulgation of the regulation or not? In other words, their argument is that there is an APA problem because there were not alternatives considered to the $15 minimum wage that the president directed.
I think that's a distinct issue, Your Honor. I don't think it relates to the regulatory.
All right, then, well, give me your response to their argument there.
So this court has explained in New Mexico Health Connections versus HHS that, quote, the APA's requirement that an agency explain its decision applies when the agency exercises its discretion, not where there was no exercise of discretion to explain. The agency here, in this rule, the agency had discretion on certain points. It did not have discretion on others. And as to the points they're challenging, whether this requirement in contracts exists at all, whether the 2018 exemption for recreational service providers is rescinded, those were decisions made by the president, not by the agency, and they were made in the exercise of authority specifically delegated to the president by Congress. So as far as I can tell, plaintiff's argument rests on the idea that after the president, exercising power specifically delegated to him, has made a choice to do X, the agency should have felt free to do not X, to do Y, and they should have explained their thinking on why they should do X, and they should have seriously considered doing Y. That doesn't make any sense. I mean, the power is committed by statute to the president. All the agency was doing here was implementing, all the agency was doing here in the parts of the rule they're challenging was implementing that directive. The agency did do other things in this rule. It did resolve questions not resolved by the president. As to those issues, they certainly could have brought an arbitrary and capricious challenge, but that's not what they've done here. So we don't dispute that the APA applies in the sense that they have a cause of action, that there's a waiver of sovereign immunity to challenge this implementing rule, but the APA, but the court cannot review under the arbitrary and capricious standard the basic choice to require this in contracts and to rescind the 2018 exemption because those were choices made by the president, and the president is not an agency under the APA, under the Supreme Court's decisions in Franklin and Dalton.
Would you indulge me? I waited too long on your opponent to ask this question. Would you give me 30 seconds and no more than 30 seconds of your comment about an inherent authority to adopt this rule?
I'll try. So
unsevered or severed from the Procurement Act.
So on that point, Your Honor, the EO does begin in the exercise of my power under the Constitution and various statutes, including FPASA. We haven't asked the court to uphold the denial of a preliminary injunction on the theory that even if this isn't authorized by FPASA, it's authorized within the president's inherent powers. So we've mainly.
So it's not issue here, and It's not an issue in this case.
I think it's an issue in the sense that some of plaintiffs' arguments are informed by the fact that this statute is confirming inherent powers. So, for example, in the major questions doctrine, I think, you know, the concern about regulatory overreach, overextending beyond an authorization delegated by Congress, is significantly diminished where a statute is bolstering an inherent constitutional power of the president. So I'm not saying that the fact that there's inherent power here is irrelevant. I'm just saying that we haven't asked the court to affirm
It's
the
not
denial.
a base. Okay, that's all I need. Thank you.
Yes. I'm happy to take any further questions the court may have. Otherwise, we ask that the denial of this preliminary injunction be affirmed.
I think that's fine.
Thank you, Your Honor.
Thank you, counsel. Round that out to a full minute, please, and then we'll go from there.
And Your Honor, I want to start my rebuttal where they ended, and that's really talking about the relief that we're requesting here. We're essentially just asking this court to extend the injunction that was already put in place by the motions panel. And the question here is really, I mean, we've talked about the merits exclusively. The question is whether there's a substantial concern that this rule is unlawful. And I think there very clearly is. And whether that is on a plain statutory language question, whether that is with the invocation of the major questions doctrine, I think this court simply has to look at the two decisions from the Sixth Circuit and the 11th Circuit reviewing very similar types of regulations using the same statute. And no matter how you slice it, whether it's plain statutory text or resorting to the major questions doctrine, this goes too far. And there are approximately 40,000 firms, just like my clients, that are non-procurement, that are seeking relief. Thank you, Your Honor.
Thank you, counsel. Thank you both. Very fine arguments. Cases submitted. As I noted, we're going to take a 10-minute break, and then we will return to hear the rest of the cases for the morning.
Court is in recess for 10 minutes.
leave this up here? Yeah. One less thing to carry.
Judge Abell, if you're there and you can hear me, I went ahead and turned your camera and the microphone off for the stream to the courtroom. So whenever you're ready, go ahead and just click OK on that prompt to start your video, okay? And I'll send you another prompt to unmute your microphone, just whenever you're ready.
The Honorable Judges of the United States Court of Appeals for the 10th Circuit.
Please be seated. The next case we have this morning is 21-8078, Fourth versus Laramie County School District. Counsel for Appellant, if you would make your appearance and then please proceed.
Good morning. May it please the court. My name is Matthew Crone on behalf of Appellant Gracie Forth. The sexual abuse that occurred in this case is horrific, disgusting, tragic. No child, let alone a 14-year-old, should undergo this level of abuse, let alone at the hands of their teacher. But this sort of abuse happens more often than it should. And it happens as often in cases like this one because school officials fail to adequately protect their students, counter to Congress's goal in enacting Title IX. The district court erred by finding that the school district lacked actual knowledge, i.e., a substantial risk of harm. Given the evidentiary record in this case, particularly when viewed in the light most favorable to the non-moving party, plaintiff appellant, the record contains ample evidence to show that the school district had actual knowledge.
So, counsel, let me just stop you there. So you concede you have to show actual knowledge.
Yes, which, as this court defined in SQ, is the substantial risk of abuse.
Thank you.
And when those warning signs were present here, in this case, and one of the principals had personally observed Mr. Meza sitting with a group of 7th grade girls, one of whom had her arm around him, while she continually stroked his face and neck. And then teachers, the very next school year, reported incident after incident, complaint after complaint to school principals. On that evidentiary record, a reasonable jury viewing that evidence in the light most favorable to appellant could find that the school district—
Is the evidence clear exactly what the teachers reported to the principals? I mean, I understood the evidence about what the teachers suspected, but it wasn't clear to me how much of that actually got reported to the principals.
Yes.
So what does the record show? I'd like to know the specific record about the reporting that occurred to the principals.
Thank you, Judge Ebel. Well, first off, there is the personal observations from the principals themselves. Principal Cunningham and his observation of the football game.
So I'm sorry.
That's not probably enough, but go ahead.
Oh, right, and I'm sorry.
Copy there. Did that incident involve the girl here?
No, it did not, Your Honor.
So maybe you can tell us what that involved. Other people.
Yes. I'm sorry as to which question. Let me answer Judge Ebel's question about the specific complaints, and then I'll return to the football game incident, if that's okay. Which is, so teachers, Shannon Hall, reported to the principals that Meza had come up to her and demanded a hall pass so that Gracie could visit him whenever she wanted, regardless of whether she was in class. And then Meza grew angry and threatening towards Ms. Hall when she denied that request. And she reported that incident to principals. Ms. Hall also reported incidents in which that Gracie was in Meza's classroom before school, after school. She was skipping classes to be in Meza's classroom. And she also reported that Meza had brought Gracie to school on a professional development day, which was a day for only teachers to be in the school location, and students were not supposed to even be in the building. Teachers Shannon Hall and Rebecca Robinson also reported an incident in which Gracie and Meza were sharing a drink.
Reported to whom? reported?
Sorry,
to
all of
whom?
those reports that I were mentioning were reported to the school principals in this case. They were reported directly to Principal Hunter, and the record is somewhat muddled as to whether other principals also received those direct complaints. I believe the teachers testified that either Cunningham or Balo were in the room when they fielded the complaints, but they couldn't recall exactly who it was. Turning to your question, Judge Ide, and the football game involved a different 7th grade girl, and Mr. Meza was sitting with a group of 7th grade girls, and this happened the school year prior to the incidents involving Gracie. And so at that football game, Mr. Meza was sitting with one of the girls, had her arm around him as she was continually stroking her face and neck. And I think this is an incident where the district court really failed to view the evidence in the light most favorable to plaintiff appellant. And the district court's description of this incident is...
But you're conceding that girl was not the plaintiff. I thought the evidence simply said that we didn't know who that girl was. But you're conceding it was not the plaintiff.
Yeah, the evidence is that we don't know who it was, but it was not Gracie, is my understanding. But it involved another girl in her class. And so the district court failed to draw reasonable inferences. And I think I would direct the court to 2 reasonable inferences that you can glean from that report. One is that Principal Cunningham stated that and this is from his notes directly, that the touching was continual. And that word is notably omitted from the district court's order. And the reason that word is so crucial is because it distinguishes it from accidental or fleeting touches, like we're at issue in the Davis v. DeKalb case, which was cited by Appellees.
And you're talking specifically about the football incident?
I'm talking about the football incident specifically, yes. And so it was not an accidental or quick touch, like a student initiating a hug. Continual touching is prolonged and it's purposeful. The other reasonable inference to draw from that incident, which went omitted by the district court, is that there is no indication that Mr. Meza got up, he walked away, he stopped the girl from touching him. And so at that point, it becomes not a student-initiated thing, but a more mutual touching, right? It becomes on purpose. He welcomed it and he encouraged it.
Okay, well, there was a report made. He was counseled about boundaries, something put in his file. It happened a year before the events at issue here. So you've got you've got a teacher who was unaware of boundary problems. What we've got to get to is this actual knowledge standard. And on that point, one of the things that I think comes up in your brief is a reference to, and I think you talked about it today, the fact that Gracie would spend time in his office. Well, other students spent time in his office too, right? So, I mean, what inference do we necessarily derive from that? I mean...
Sure. Well, excessive time in of itself may be part of the actual knowledge puzzle, but Appellant does not contend that a student spending time outside of class hours with a teacher by itself is sufficient under the actual knowledge standard. Rather, I would argue that it's a piece of the cumulative puzzle. And although there were some reports of other students spending time with Meza in his classroom, there were 5 separate reports during her 8th grade year that were specific to Gracie herself. There was, I believe, 1 report that was sort of generalized commentary about Meza spending time with students generally. But there were 5 distinct reports about Gracie. And turning back to the football game, I don't believe that it is just a boundary issue. I view this, and I think a reasonable jury could infer this as an act of sexual harassment, as other district courts have found that face touching can be deemed sexual in nature.
Well, he wasn't touching her face, she was touching his face. And And there was, am I right on that? That was my understanding of how that played out, right?
Yes,
And-
she was touching his
Okay.
face.
And I'm not, believe me, I'm not suggesting she was consenting or anything of that
Right.
sort. That's not the point. My point, however, is that the principal treated that as an instance of him just not recognizing that properly as a teacher, that wasn't something that he should be doing. So, I mean, that one incident a year prior, which didn't involve him actually aggressively doing anything to her, I mean, that gives for at least, why is it that just an inference of bad judgment that could theoretically have gone corrected at that point?
It might have, except we don't know. Well, first off, I think that Principal Cunningham was derelict in his lack of investigation into this. We have no explanation from Meza in the record as to why, from Cunningham's observations, as to why he was allowing this girl to do this. And to your point that she was indeed the one that was touching him, as opposed, but I think that would matter if the touching was fleeting or quick, but I think the prolonged nature of the touching differentiates it and makes that fact as who was touching who virtually negligible. I'd also, to the extent that the record casts doubt as to whether the school officials had actual knowledge, I think any doubt can be dispelled by Principal Hunter's conversation with the Garcias at Cahill Park. And I want to set that scene for you in case it's a little unclear from the briefing as to the timeline. Because this conversation occurred just days after Gracie had finally reported the abuse to police. And she, at the police station, she had contacted her mother, and she told her family about what had happened. But Principal Hunter did not know, and nobody from the school district knew at the time of that conversation. And from when Principal Hunter, they had a mutual friend, and she was asking how Gracie was doing, and his face fell. People are very adept at reading emotions. And Principal Hunter's mind didn't jump to, oh no, maybe Gracie got in a car accident, or she had a bad breakup, or some other calamity. Principal Hunter's mind went straight to Meza. And she discussed her alleged counseling efforts with him, saying that she talked to him over and over again, which I think that there's contradictory evidence in the record on that point, because she denied.
Wasn't that the conversation where the idea of adoption came up?
No, Your Honor. That is a completely different conversation.
Okay. All right, go ahead.
And I'm not focusing as much on the adoption issue in this appeal. This is where
Can I do, we've got the detour. We've got the detour of the adoption. Let's just put a nail on that. You're saying you're not focusing on it. I mean, I didn't know what to make of that. It's very odd for a principal to adopt a student. But you're telling this court that you're not relying on that, so we should not worry ourselves about it. Is that right?
No, I'm sorry if I misspoke. And I would like to save some time for rebuttal as well. I know we're getting close here. But I think that the fact that he adopted her is part of the cumulative puzzle here that goes to the actual knowledge standard. But there was about a year and a half, 2 years after the adoption where we don't have the same sort of complaints in the record. And I think the import of that is that Meza was using the adoption as a smokescreen to cover up his relationship with Gracie, because many of the behaviors
and the principals knew. The principals knew about the adoption.
The principals knew about the adoption, but they did not know that she had gone to the police and stated that Meza was sexually abusing her.
Okay, but this conversation that you were referring to, and I'm sorry if I mixed this up, but the conversation you were referring to, that happened before the adoption then?
That conversation happened after the adoption.
It happened after the adoption,
Yes.
but the adoption did not come up, was not part of that conversation.
No, it's how they connected the dots. Vince Garcia had stated he had an adopted daughter. Then, based on that information, Principal Hunter asked, oh, it's not Gracie, is it? He said it was. She said, how is she doing? His face falls. She goes, he didn't. And Vince says he did, and then she says, I talked to him over and over
Okay,
again.
so adoption was within the confines of that conversation.
Yeah, just in terms of making the connection as to who Gracie was. You know, the subjective, I think the reasonable inference to draw from this conversation is that Principal Hunter subjectively suspected that Mesa was at risk. Defendants have not, they've said that our interpretation of that conversation is speculative, but they've not offered any alternative explanation, nor do Principal Hunter's comments make any sense otherwise. And there's numerous courts that have found that although it's not a subjective standard for actual knowledge, but that subjective knowledge is highly relevant. And so, well, I'm out of time, but would you?
We'll allow some time for rebuttal.
Okay. Well, I would just sort of summarize the main point here is that if a principal personally believes that and has the knowledge in her head that a teacher poses a substantial risk to students, and I think a jury could certainly infer and find that the principal had that knowledge. Thank you.
Thank you, counsel.
May it please the court, counsel. I'm Lloyd Smith from Cheyenne, Wyoming, representing Laramie County School District Number 1.
Well, Mr. Smith, what is the alternative explanation for that weird conversation in which the adoption came up and the reaction of the principal? I mean, if it were not suggestive of the fact that the principal had subjective awareness that something was going on improper, if it didn't mean that, what did it mean?
The only subjective knowledge referenced by that episode was that of the adoptive grandfather, Vince Garcia. He is the one, he's the one who is speculating as to what she thought. She didn't say that. And if you look at the testimony, and I included that cross-examination of Vince Garcia in my brief. He said, it came up that he was the grandfather of Ms. Forth, and she said, how are they? And according to him, his face turned ashen, and she said he didn't. And from that, he gleans that she subjectively meant he didn't have sexual relations with the plaintiff. That's his interpretation of her demeanor. She didn't say that, and in fact, her testimony, which I cite in the brief, was, or his testimony, he said in a separate page or so behind that or after that, he says she was very surprised to learn that that Mesa had been accused of sexually abusing Ms. Forth. That is what she said. I mean, that was the knowledge, and she didn't. And then there's no evidence there of her subjective intent. It's his subjective.
What did she say about the episode later? I assume she was deposed, right?
I don't know if her deposition, I don't remember the chronology, might have been before the deposition of Mr. Garcia.
So we don't have her reaction to the Garcia episode?
We don't have her, I don't think we have that. It's certainly not in the record. We have the key piece of evidence being that Garcia says when she was told that in the park there that Mesa had been accused of sexually abusing Ms. Forth, she was very surprised. That's the only evidence of what she knew, not his reading of the tea leaves based on her facial expression, which as an analogy, I would say that would be like me reading the court's demeanor and saying, I know what you're going to decide. You haven't told me that. I'm just guessing, and that's what he was doing. He was guessing.
He didn't. Upon first reflection, somewhat damning. I mean, it suggests that he didn't do something he shouldn't be doing, doesn't it? I mean, and to that point, let me just go with the assumption for a second, and I'm clear. I'm just asking you to assume this.
Sure.
Let's assume that it did give rise to some inference of subjective knowledge. How does that play into the actual knowledge standard?
Oh, it doesn't, because it's a speculation of some subjective knowledge of a person. It doesn't show the district had actual knowledge of a substantial risk of abuse.
But she was a principal, though.
She was a principal.
And therefore, wouldn't she be, in some sense, her knowledge attributed to the district?
Her knowledge, if she had knowledge of a substantial risk, that would be sufficient to be attributed to the district. But be aware also of the time frame of this. This was in June of 2017, a few weeks after Mesa had been arrested. Now, she didn't know about the arrest, but this was, I think she had left the Johnson Junior High a year or two before. She had not even been a principal at that school for some period of time.
All right.
What authority do you have that actual knowledge requires more than a suspicion?
Well, I think the cases from this court and from the Gebser decision from the United States Supreme Court requires that it be sufficient to supply actual notice of a substantial risk of harm. And I'll point out.
Yeah, so a suspicion could be, I have actual knowledge, and my suspicion is that it's causing harm to this victim, and therefore a likelihood that that victim may be, the word suspicion could apply either to the knowledge or to the consequences of that knowledge. And she might say, I have actual knowledge of things that I think were improper, and that's led me to a suspicion that something improper is happening. I can't say it's a confirmation of it because I haven't gotten a confession, but at that point, suspicion becomes much less troublesome. If it's only, I have a suspicion that something happened, that's a different story. I mean, it depends on where the word suspicion comes up in the analysis.
Right, and this whole
in the conclusion or in the underlying data.
And this episode is removed, it's remote, and it's several layers of inference that the plaintiffs insist that this court should be able to make to imply or infer actual knowledge. And to that, I would emphasize that the actual knowledge standard is a high bar, and that's been noted by the Gebser court, saying that it's a high bar. This is not a negligence standard. It's not a should-have-known standard. It's not a constructive notice standard. It's definitely a high bar. And the court in Gebser talked about the policy reason for that, that there's a policy reason that there's a high bar for that. And they said that is, let me find that, that the central purpose of requiring actual notice is to avoid diverting educational funding from beneficial uses where the recipient was unaware of the discrimination as was willing to take corrective measures had they been aware. And that is the distinction or the reason for the high bar.
But let me go with that and jump off from that proposition, assuming that's right. Well, why isn't there some support for risk? It's actual knowledge of a substantial risk of abuse. It's not, and so high bar or not, we're not talking about actual knowledge of abuse. We're talking about actual knowledge of a substantial risk of abuse. And I'm just looking at some of these incidents. The special relationship incident in itself, why didn't that set off alarm bells for somebody? You have a teacher going to somebody saying, I want her in my classroom whenever she wants to be because she and I have a special relationship. You add that, and I could go through a number of these, including the ones where she's there on professional development day and that kind of thing. But if you just have that one, and then you have drinking out of the same Coke, I'm sort of at a loss for saying why that would not set off alarm bells for somebody that something is going on and something is going on of a sexual nature.
Well, again, I think that Judge Johnson got it correct, that this is inappropriate and unprofessional. But regarding the time in the classroom, excuse me, Christina Hunter, the principal, testified that she did talk, she and another principal, I can't remember which one, talked to Mesa about students being in the classroom, but she said it was not specific to Ms. Forth. It was that he had many students coming to his classroom, as does another teacher, Ms. Mazzoni.
Yes, and that was the dialogue I had with opposing counsel. I get that.
Right.
But the point is, by Mesa's own characterization of his relationship with Ms. Forth, it was a special relationship. And so you add that to the soda, I don't know whether it's Coke or not, the soda incident, and I understand your position that there's a high bar, but what I'm trying to give me your best case to suggest. Let's just take those two. Apart from all this all this movement in and out of his office, let's just take those two. What's your best case to suggest the alarm bells equal to notice of a substantial risk of abuse should not have gone off when they knew those two things?
Well, I mean, the drinking out of a can of same pop, that's an odd thing, but it's not.
Oh, it's odd.
But it's not, I don't think it's wacky. I mean, I can picture that happening. I can see a coach in a football team doing that. I can see that kind of thing happening. So I don't think it's inappropriate. I think it's clearly inappropriate and should be the subject of counseling, and there was counseling given to
I
him.
guess my point was that you add that in the special relationship. And again, I'm not talking about traffic in Mr. Mesa's office. He could have been a real popular teacher for all I know.
He was.
That's not my point. My point is by his own characterization of what was going on between him and Ms. Forth, they had a special relationship. So she wasn't like any other student. She was special. And so in that context, what I want to know from you, all I'm saying is, what's your hardest case to tell me, there's nothing to worry about here, there's nothing to see? Those two incidents.
Special relationship because she was a girl from some troubled family.
I'm talking about judicial decision, if you have one.
Right. Well, I'm not talking about a judicial. I'm just saying.
And I'm asking you for a judicial decision to help me know that I shouldn't worry about those two things. I mean, I know you've cited cases in your brief. Which one would you tell me to look at to allay my concern about those two things?
Well, I don't think I can point to a brief where those words were used or something of that nature was used, but we did point to a number of cases where behavior was, perhaps raised eyebrows. But the ones where the courts have found actual knowledge, the behavior was far more egregious than in this case. And I point out, none of that is gender or sexual in nature.
Drinking out of the same Coke with somebody of another gender is not potentially sexual in nature? That's a pretty intimate act, isn't it?
I don't know. I guess I wouldn't see it as that, but.
I don't. Okay. All right.
But, the other cases, and we cited in our brief, and I won't go through all of them, but the conduct was much more egregious, including the Hilldale case, Judge Holmes, I know you were involved in, where the band teacher was observed by another student the student goes to the hotel room door on an out-of-town trip. The teacher opens the door, and this student sees a female student lying on the band teacher's bed, goes to the administration, reports it, and says, I think that guy's a pedophile. I mean, that's the kind of egregious conduct that is found in the cases where the court has found actual knowledge. And before I run out of time, I want to point this
quickly. I think that everybody agreed that the discovery is complete in this case. Nobody resisted a summary judgment motion because discovery hadn't been completed. Is that right?
That's correct.
So it's not like you might find some more stuff if this case stayed alive for a while.
I would point out to the court that this case went through exhaustive discovery, massive document discovery. I think we had 14 depositions. Virtually every principal at the junior high was deposed. The school district administrator from the district, human resources, it was exhaustively
So what we saw in summary judgment is what you'd see at trial.
What do we take from the fact that some of the principals identified the conduct associated with Ms. Meza and Mr. Forth as grooming? And they, by their own characterization, saw markers of the lead up to sexual conduct in that. At least that's my recollection, that there were some statements in the record. You look quizzical, so perhaps I'm wrong. Is that?
I'm not recalling those statements like that in the record.
Really? Okay, all right.
I'd like to close with kind of giving a perspective on this. As we've just discussed, there was exhaustive discovery in this case. And principals and teachers and administrators were deposed. And there are a handful of incidents brought up by plaintiffs, some of which clearly the administration never knew about. They didn't know about the out-of-town trips, the running trips. They didn't know about the locker room joking by the coaches. They didn't know any of that. But what we have is we've scrutinized a massive record in hindsight, and plaintiffs essentially are asking this court to apply a should-have-known standard, that there were some red flags. Well, sitting here today, yeah, we can say that.
Well, correct me if I'm wrong, going to my last point, and I won't pursue it beyond asking this next question. I have in my notes, anyway, that Ms. Cunningham testified that issuing frequent passes to a particular student could be a, quote, sign of grooming. Did she not say that?
She probably said that. That wasn't asked as, in terms of this student. I believe that was asked as a hypothetical. Would you agree?
Well, yeah, well, even if it's not in terms of this student, the question is what would be the attributes of his conduct that would have given rise to notice, right? And if there are certain things that would have been innocuous on some planet other than ours, but in the context of the educational setting, one would know that those are markers of grooming. Why isn't that relevant to the actual notice analysis?
Well, again, it wasn't just her that was asking for passes. It was other students, and it wasn't just his room. It was also Mazzoni's room. So maybe his was a little more upfront than some of the others, but there was a lot of that going on.
You just said it wasn't just her, but other students too. Is there evidence of how many other students got special passes to his office?
I don't think there's evidence of how many got special passes. There's evidence that there were requests for passes to his office, and there's evidence that students were in his room a lot, including, of course, because he was also a track coach, and so they had a reason to be there oftentimes. But there's, that kind of involves in the evidence also. So anyway, this is looking at this massive record from hindsight. There are some red flags, but again, that goes to a negligence standard. Is it a should-have-known standard? But it's not. If it was a should-have-known standard, it's a different outcome. But that it's not what.
Well, but the should-have-known, as Chief Judge Holmes said, should-have-known is not that you should have known there was abuse. All it was you should have known that there was a substantial risk of abuse.
Correct. But it should have known still. No, should have known doesn't cut it. They have to have an actual knowledge of a substantial.
I mean, actual knowledge, but not of the abuse, only a substantial risk.
Correct. That is true. And
I shouldn't have used should have known, except that you used it, so I just parroted it.
Right. Well, I did that to show that's not the standard. But that's in our contingent.
I agree.
Where plaintiffs are kind of going. Go ahead.
If you have something burning to say, I want to hear it, but otherwise, we're
I'll just finish with this, and we pointed it out in our briefing. The relationship went on in the marital home of Mesa for a year and a half at least, and his wife did not know, and if anybody should have known, it was her. This shows how adept they were at hiding this relationship, but yet they want to say that the school district should have picked up on something that she didn't even pick up on. So thank you.
Thank you, counsel.
Chief, may I ask one factual question?
Of course you can.
Chief,
Yes.
Just one quick one. When did he adopt, does the evidence show when he adopted her? When in this whole process he adopted her?
Yes, it does. So, and this is in the record. He moved into the Mezos home, in the Mezos home in October of 2015. They were awarded guardianship in December of 2015, and the adoption became final in May of 2016. So she was living in that home from October 2015 until the date she went to the police in May of 2017.
Oh, so awarded guardianship in December 2015, did I hear you correctly?
Correctly.
And then they got full adoption when?
In May of 2016.
Okay, great. All right, thank you.
Thank you.
All right, how much time does he have? Oh, by how much? Okay, let's go with a good 2 minutes, and that's going to be a hard 2 minutes. And you don't have to take it if you don't want it, but you got it.
I want it. Thank you.
All right.
I'm just going to bullet point a few of the factual issues here. There's no evidence that there were any special passes for any other students. There was testimony, as Judge Holmes pointed out, that his principals received training, and they were trained to recognize many of the signs. The incidents that were here, they recognized it as grooming. They took no action. With respect to the soda sharing incident, I would emphasize that 6 students, middle school students, reported this to their teachers. Reasonable inference, they weren't concerned about germs. This is pre-COVID, went far beyond the boundaries of a normal student-teacher conversation. With respect to Principal Hunter's conversation.
Could I ask 6 students, just refresh my recollection, 6 students separately, or?
I think it was 2 groups of 3 students reported to 2 separate teachers.
Okay.
The conversation in the park, perhaps I missed it, but I still did not hear an alternative explanation for Principal Hunter's comments in the park.
Well, this is what I want to know. I mean, is there anywhere in the record where Principal Hunter says what her reaction was to that?
Yes,
Explain
so
that.
Principal Hunter, I believe she testified that she did not deny having this conversation with the Garcias. She didn't recall the contents, much as she did not recall receiving any of the reports that the teachers made to her.
So she doesn't say that her reaction was a result of any sort of knowledge?
No, but she does not deny that either. And a reasonable jury can make a credibility determination based on this conversation. It was not just Vince Garcia, as counsel led you to believe. Becky Garcia, Gracie's mother, also testified. She participated in this conversation, and to her, Principal Hunter testified that, or stated that she suspected it was a sexual issue. Your Honors, I'd go back to
We're wrapping up. Thank you, counsel, for your very fine arguments, both of you.
Thank you.
Okay. Next case for the morning is 21-8088, Cups versus Pioneer Canal-Lake Hattie Irrigation District. Counsel for Appellant, would you please make your appearance and proceed?
Good morning. May it please the court, counsel. My name is Brandon Jensen. I'm an attorney from Cheyenne, and I represent the landowners in this case. This case concerns the scope and extent of a right-of-way for a reservoir situated on federal lands near Laramie, Wyoming. The defendant, the Irrigation District, contends that the scope of its right-of-way should be the physical limitations of the dam and the spillway. However, this is not the first appeal to this court in this case. In the original appeal, this court held that the boundaries of the right-of-way were to be determined solely by reference to the map that was approved by the Department of the Interior. I quote,
Was that the word solely, or did they use the word anchored?
They did not use the word solely, and I do not recall if the word.
Well, I think then that was a misrepresentation for you to so emphasize that word. I know that the word anchored was there, but that's very different from solely, so I think it's a little misleading. So try to be as strict to the information and facts as you can.
And I would quote the decision of this court that said other factors other than the map that arguably could be advanced as bearing on the scope of its rights are irrelevant. Those are the words of this court.
That's a fair defense. That's fine. Thank you. I understand it now.
This court also said that the approved map depicted a specific geographic area. So on remand, despite overwhelming evidence to the contrary, the lower court determined that the right-of-way boundary could not be located based on the map because the map contained errors and was otherwise unreliable and inaccurate.
Isn't there a point in which the map would become so flawed that one would have to deviate from the map?
I would say if the Irrigation District cannot rely upon its own map to find its own right-of-way, there is a valid argument that they never met the requirements of the statute in the first place and that its right-of-way should be declared invalid. I would say that is not the position we have taken in this case. That is not what we want to see happen. The right-of-way can, in fact, be found on the ground with the map that has been approved by the Department of the Interior, and in fact has been found on the ground on 2 separate occasions by more than one surveyor using different methodologies, different equipment, and more than 70 years apart from one another.
And so it is your position then that given the fact that they did present this map and it was approved by the Department of Interior, that even if it's been shown subsequently that there were errors in that map, they're stuck with that map?
Correct.
Okay.
And I would cite, I believe there is over 100 years of case law that comes from not only this circuit, but from the Supreme Court saying it is not what you want the map to show, but what the map actually shows on the ground. There is a variety of surveying standards and methodologies that have been developed over time to account for errors and discrepancies that occur in a survey. And the surveyor's mistakes in this case do not impeach the overall integrity of the survey. It can, in fact, be located on the ground today. For example, the BLM was able to locate the right-of-way on the ground in the 1940s. And in that time, obviously, they did not have the benefit of computers or GPS. What they did, in fact, have the benefit of were monuments set by the original surveyor. And those monuments are key in the fact that as the BLM went along the route and measured so many feet in a certain direction, and when they reached the end of that distance, there was, in fact, a monument on the ground set by the original surveyor. And as they turned the corner and went another certain specific distance, there was yet another monument. And in fact, on this section alone, there were no fewer than 12 monuments set by the original surveyor that the BLM relied upon to find the true location of the boundary of the right-of-way.
Didn't the district court have some concerns about the BLM resurvey, specifically related to their failure to determine a high water line and the spillway elevation? I mean, the district court did express some concern about how much we could rely upon the BLM resurvey to validate the Rosencrantz line. Am I recalling that correctly?
Yes, you do recall that correctly. And I would say that the prior decision from this court says that elevation or the elevation of the spillway or the high water line, any of those other characteristics are irrelevant. They do not matter in terms of laying out the boundary of the survey. The survey can be located on the ground irregardless of the high water line, the elevation of the dam, or any of those other characteristics that both the lower court and the defendant have called out into question.
So counsel, what are you asking us to do? Or what are you asking us to say? Reverse based on the fact that the district court didn't take this court's previous decision seriously, and just reiterate that the district court can only look at that original survey? Is that what you're asking us to do?
No, with all due respect, Your Honor, because I think that's already been done. What we're asking the court to do is to reverse the lower court and say you cannot have the right-of-way based specifically on an elevation. And the second part of this, we would ask this court to order the lower court to use the BLM's resurvey as the boundary of the reservoir. That survey has stood for 70 to 75 years. That survey defined the boundaries and the rights of way of all the parties in this case. That survey was based on compelling evidence found on the ground that's attributed to the original surveyor. That survey has been monumented and staked into the ground permanently for all time so that all parties and all surveyors that come thereafter can find the actual boundary of that line.
Because the BLM confirmed the Rosencrantz line.
Correct.
Okay, let me, Judge Ide raises a very good point in terms of just thinking procedurally how this ends up. Let's assume for the moment that we were to reverse, and let's say it says something like, district court considered factors that we had determined in the first case were irrelevant. Reverse that judgment on that ground. What really remains to be done? And that goes to the question of the notion of as often we are reluctant to micromanage further proceedings. And therefore, what I want to know is what essentially do we have to do beyond reverse, and what really remains for the district court to do if it were the case to go back under that circumstance?
If I understand your question.
My point is, if we said reverse, the district court considered irrelevant factors, and we say remand for further proceedings, what are those further proceedings? What remains to be done?
Well, there would still need to be the matter of making sure we know exactly where the boundary is on the ground. And then phase two of the case would be damages, if any, owed to the plaintiffs.
Okay, and all right, and that's your clients. Okay, so, all right.
Wait a minute, but you said that there was a survey that you want to rely on that does put it on the ground. So why would you do anything more than just simply say reaffirm that earlier survey?
And that, in our opinion, that would resolve the matter.
That's what you want, but the first case didn't deal with that, right?
Correct.
Okay, so what you're saying is, ideally from your point of view, what would happen is there are two phases. Two things have to happen in further proceedings. One, what's the line going to be? Two, the issue of damages.
Correct.
If I understood your answer, Judge Ide, it would be your preference anyway, if we were to reverse, that we say what the line is. The line is going to be the BLM resurvey, and then the only question that remains after that is damages.
Correct.
Okay.
Counsel, I want to just, because you paused, can you please help me understand why there's federal jurisdiction over this case?
Wow, that goes back to the original appeal. This involves a federal right-of-way on federal lands. The scope of the defendant's right-of-way for their reservoir is based on a federal statute from the 1890s, and it sits on federal land. So there was precedent from this court, and you'll have to excuse me, I haven't looked at that case law in a long time, but there is precedent from this court that says a federal statute and a federal right-of-way provides federal jurisdiction for the federal courts to decide this matter. I can see.
And it was entirely on federal land. There was no private land involved.
Except for the plaintiff's land that lies adjacent to the reservoir. It is our contention that the entire scope if you based on the original map, the scope of the reservoir lies entirely on federal land. We also think that there is also additional grounds for reversing the lower court's decision. It based its decision on virtually everything that this court found was to be irrelevant, such as elevation, the infeasibility of using the reservoir, the height of the dam, the intended high water elevation, and I would also note for the fact that the defendant's own surveyor testified repeatedly at trial that none of this elevation that was set forth by the district court is in any way based on or can be relied upon the original approved map, that they are two completely separate things and one is not the other.
Let me shift gears for a quick second here to talk about the district court's decision as it related to the 50 feet on each side. The 946 grant of right-of-way, 50 feet on each side.
Yes.
Why, it's my understanding, maybe incorrectly, I thought that you disagreed with that determination.
We do disagree.
Okay, and well, then go ahead, finish.
The statute does, Section 18 of the statute does provide for 50 additional feet. But Section 21 of the statute says nothing in the prior sections. Nothing in the prior sections shall authorize a canal or a right-of-way except only so far as may be necessary for the construction, maintenance, and care of said canal or ditch.
And why doesn't that just speak to how you use your 50 feet?
It goes back to the original 50 feet should have been approved by the Department of the Interior.
Well, the statute says you get 50 feet. Why does the Department of Interior have to do anything about that?
Because Section 21 of the statute says that 50 feet is only as if it's necessary for the construction, maintenance, and care of the reservoir.
It didn't say 50 feet it says whatever went on before, as long as it's necessary for these acts that you listed. But I guess my point is, why can one not construe that language as just cabining what you do with the 50 feet that the unambiguous language of 946 gave you to begin with?
That would be one construction. It's our position that the reference to the 50 feet is also in a sentence that says to the extent of the ground occupied by the water of the reservoir, and 50 feet. This court held in the prior case that the language to the extent of the ground occupied by the reservoir is subject to the approval of the map. So if that language to the extent of the ground occupied by the water of the reservoir is subject to the approval of the map, so must be the additional 50 feet, because both of those provisions come from the exact same sentence.
All right.
Unless there's any further questions, we would ask that this court reverse the lower court, and I would reserve the remainder of my time for rebuttal.
All right. Thank you, counsel.
May it please the court, counsel. Good morning. I believe we're not. We're in the afternoon. Greg Weiss of Penson Macmillan LLC, Cheyenne, Wyoming, on behalf of Appellee, Pioneer Canal-Lake Hattie Irrigation District. I'd like to begin by correcting a couple of misstatements. The district court decision absolutely, unequivocally was not based on elevation. And in fact, after the 10th Circuit remand from 2019, the district court judge said, I will not make my decision based on elevation. And the surveyor hired by my client, the only surveyor that went out and conducted a survey after the 2019 remand, he specifically and repeatedly said he did not make his determination as to the location of the Rosecrans right-of-way line using elevation. This is a reservoir that has 3 dimensions: length, width, height. Necessarily, as part of that consideration, every point along the line, wherever the right-of-way line is, every single point is going to have an elevation. It's obvious. Every point in this room has an elevation. But the surveyor hired by my client, whose crew invested over 700 hours of time at the reservoir, in contrast to actual 0 hours of time spent by the plaintiffs conducting a full survey of the reservoir.
And let's talk about that for a second.
Yes.
Well, why 700 hours to begin with? You had a Rosencrantz map, you had the BLM who did a resurvey of that map. Well, the only thing that, and why isn't it a natural inference that you spent those 700 hours trying to determine that those 2 surveys are wrong? And if you did that, why is that relevant at all?
It's just demonstrative of the fact of how much time the surveyor spent trying to reconcile the problems with the Rosecrans map and with the BLM survey.
And if they are problem riddled, what difference does it make? That map was approved by the federal government, and that is, at least by the statute and by the law, the case of the first case. You're stuck with that, aren't you?
I'm absolutely stuck with it, and I'm happy to be stuck with it. Because here's what happened on remand. The district court, taking a look at this decision from this court in 2019, said, okay, we're going to confine the discussion at the second trial based upon what's in the Rosecrans map and the survey. Here's what Rosecrans map says. He intended to lay out a level line, and the appellants, the plaintiff's own surveyor, said a level line is a line at 1 elevation. Second, the Rosecrans map, and this is on the face of the map, says that this is the proposed line of the reservoir because the reservoir wasn't built yet. He also said that in his field notes that he intended to establish the true water line, and also on the face of the Rosecrans map is a specific statement that says, this right-of-way is being acquired under the 1891 Act to store irrigation water, for the purpose of storing irrigation water, which is exactly what Section 946 says. And so what the surveyor did by all of his time is, as he went out and conducted the survey of the entire perimeter of the reservoir, and this is why the time spent is significant, because as he did that, he noticed a lot of problems with the Rosecrans survey. And in fact, that's a key point to emphasize, is that there was new evidence. And Judge Holm, you asked, I believe, at some point, couldn't the map become so flawed you have to look elsewhere? Well, in this case, the surveyor did not look elsewhere. I'll touch on that in a moment. But what he said is the Rosecrans map had so much error, both in the courses and the distances of the courses, that he was forced to try to take account of all of those errors. The most significant testimony from trial, hands down, was the admission by the plaintiff's own surveyor that said the line that he believed should be the right-of-way line. He admitted that as every new surveyor goes out and tries to locate that line, they're not going to be able to locate that line in the same place because of the errors that were in the Rosecrans survey. He admitted it. He said, I used a different method than Surveyor Coffey, the Irrigation District surveyor, to try to take account of Rosecrans errors. And upon questioning, he admitted that as every new surveyor goes out and tries to identify the location of that line, they're not going to be able to replicate that. And the key reason this court reversed in 2019 was the district court's determination that the right-of-way line is transitory. And of course, after the 2019 decision, on behalf of my client, I petitioned for rehearing. It was denied. And I'm glad it was denied, because what occurred to me as I read the decision and we prepared ourselves for trial is that, in fact, there does need to be certainty as to the location of the line. Everybody's got to know where that's at. And the line that the appellants assert should serve as the right-of-way line is transitory. Their own professional engineer admitted that over time that's going to change. And
It's not going to change with the high water level. And the fact that you would do a resurvey, the BLM staked out the Rosencrantz line, and they confirmed, did they not? I mean, and again, we're not talking about whether the Rosencrantz survey was flawless. What we're talking about is whether we had a government entity that came along, I guess, what, 40 years later or something like that, and did their own confirmation of that. And so you have a line. Do we not? I mean, why is that transitory to the extent that the BLM confirmed the line?
So we know that the Rosecrans map, which was approved by the Department of Interior in 1923, the court should remember that the Department of Interior approved a level line. When the BLM went out and surveyed, purportedly resurveyed the Rosecrans line, they knew, they should have known that there was a big problem, because as they were laying out the portion of the Rosecrans line that goes in front of the cabin lots, the line that they said is this is the Rosecrans line. It went under the surface of the water that they encountered at that time. If that's so, how could that BLM survey line be accurate? And in fact, there was a reference to monuments that were placed by Rosecrans. The testimony at trial was not that Rosecrans placed any monuments. His survey notes are devoid of any reference to monuments. What the BLM did is they retraced that part, and it was just part of the Rosecrans line. They laid out some monuments, and those monuments differed in elevation dramatically. Some of those lines, some of the line that the BLM laid out was actually below the dead pool line of the lake. And some of those points that the BLM monuments were above the spillway. Yes, Judge.
The monuments were laid out by the BLM and not by Rosencrantz?
Absolutely. There was testimony from my client surveyor that there was absolutely no evidence that some wooden stakes that the BLM found were monuments that had been placed by Rosecrans. There's a long discussion in the testimony about the pedigree of a monument. And when a surveyor places a monument, they are to put that in their survey notes. And that did not happen with Rosecrans. But the point about the Rosecrans survey and the BLM's attempt to retrace it is that the BLM was directed to establish the high water line of the lake. The BLM did not do that. Had they done that, we wouldn't be here today, because they were instructed to separate the plaintiff's cabin lots from the high water line of the lake. Instead, they went out and they conducted the survey before the survey instructions were completed, by the way. And as they did so, they ran across the point where the line went under the water that they then encountered in the fall of the year. That should have told the BLM there's a problem here. Why does our retracement of Rosecrans level line, why does it go below the surface of the water?
Let me ask a fairly fundamental question that eludes me the answer now, so I want to hear it from you. What is the legal effect of the BLM's resurvey? I mean, the BLM purported to be confirming and validating the Rosencrantz line. I know what the effect of the Rosencrantz map is. What is the legal import of what the BLM did?
The legal import of what the BLM did is they created the cabin lots. But my brief cites case law that says that a resurvey of the Rosecrans line by the BLM cannot affect the easement that was granted and approved by the Department of Interior to the Irrigation District.
It can't approve the easement, which was reflected in the map that was submitted to the BLM. Is that what you're saying?
I'm saying that the BLM resurvey cannot alter the boundaries of my client's right-of-way easement under the 1891 Act.
Yes, but what defined your client's rights were they not the Rosencrantz map that was submitted and approved by the government, the Department of Interior at the time?
Yes.
And I guess my point is this, and what I want to get clear, when the BLM came out and did their resurvey purporting to validate the Rosencrantz survey, which had been approved, the Rosencrantz map, when they did that, what deference do we owe that process? Because it purported to be the government validating what the government had previously approved. And so my question to you is, what is the level of deference that is owed to that?
This court owes no deference to that.
What is the case that you can give me that says that?
Because it's in my brief, Your Honor.
Okay.
I point out that a resurvey of the Rosecrans line cannot affect the right-of-way granted and approved by the Department of Interior.
Well, it cannot affect if they did something dramatically different, but if the determination was made that they really validated what the Rosencrantz map did to begin with, then all we're doing is saying that we're adhering to what the Rosencrantz map is, which you, as a matter of law, I know you are bound by that. And so if the BLM comes out and does that, I guess what I'm getting at is what seems to be a scenario that's playing out here. You have the BLM do its resurvey. They say, this is what we find the Rosencrantz line to be. Then you hire somebody to come out and say, well, you know, there are flaws in both what the Rosencrantz did and what the BLM did. So listen to us. Take our resurvey. What basis do you have for us saying we're going to choose that, your survey, over this that's over here?
Thank you for asking that question, Your Honor. It is because my client relied on a portion of the Rosecrans survey. Dave Coffey, my client's surveyor, said, you know what? I looked at the retrace line, and there was a portion of that line that demonstrated Rosecrans' intent. And it's an intent that governs when a survey has errors. And what he said is, I found strict conformity between the location of a portion of the retrace Rosecrans line with my survey from 2021 in the area of the spillway in the dam. And my client surveyor said, there's a portion of the Rosecrans survey, the map, that does in fact show what his intent was and shows where he intended to establish his level.
Well, the fact of the matter is the government didn't approve a portion of the Rosecrans map. It approved the Rosecrans map. And so this idea of discerning what Rosecrans' intent was, I mean, why is that even relevant if it's only based on a portion of the map?
Because it's critical that they did approve the entirety of the map. And this court said in 2019, look for conformity. The line that Rosecrans laid out was fixed to the original topography of the ground. It's in page 23 of this court's 2019 decision. But as I close, let me make one point. The line, as asserted by the appellants, that should serve as a right-of-way line, is absolutely in derogation of the 1891 Act, because that line is located in part below the dead pool elevation of the reservoir. And as a result, if that line is to serve as the right-of-way line, absolutely no water could be stored by the Irrigation District. There was testimony at trial to that point. And so it would render the easement meaningless if that line served as the right-of-way line. Thank you,
Counsel.
So we can't, so Chief, can I ask a couple of additional questions? So that means that you're not really arguing we adopt the BLM resurvey because you say that survey would say that no water could be stored.
The line as asserted by the appellants would allow storage of no irrigation water because it lies below the dead.
The line by the BLM, that would allow water, would it not?
No, because the appellants are relying on the retracement done by my client which purports to line up with the BLM resurvey. They're one and the same, according to the appellants. So neither the BLM
But
line.
we have the BLM survey.
Yes, Your Honor, I'm not sure.
Support that survey. Does that survey allow water in the reservoir or not?
It does not, Your Honor. It absolutely does not. If the court has no further questions, thank you.
Thank you, counsel. Let's see. Okay, please, counsel.
Just a couple of quick points. The reservoir can store water. The BLM's resurvey took place 40 years after the reservoir had been constructed, and the Federal Register notice in which it published its intent to divide the lands, which eventually went to my clients, specifically says the reservoir has been operating at capacity up to this point for the last 35 years.
Remind me, what is the legal import of the BLM resurvey? In other words, if we ended up in a world, which I think we're in this world, where you have the coffee survey and its work, and you had the BLM survey from 40 years ago, what gives weight to the BLM survey as a matter of law vis-a-vis this new evidence that comes in from the coffee survey?
The BLM survey is entitled to substantial deference because that is a special expertise that is used by an agency of the federal government. And they use that expertise in terms of not only identifying the boundary of the reservoir, but delineating the boundaries of the plaintiff's properties as well.
You have cases in your brief regarding that? Okay, thank you.
And when the BLM, the deeds to the plaintiff's property issued after that BLM survey?
Yes.
Relied on the BLM survey?
Relied, I think he's.
Yes. Yes, you could not acquire the private property in this case unless you built a structure on it and then paid the federal government money. So yes, in order to get the land, they had to rely on the BLM survey. That's what subdivided the property in the first place.
And the BLM survey is the only one that put any monuments on the ground?
No, I would disagree with that point. The BLM did put permanent markers on the ground, but it is our contention that the original surveyor also used markers on the ground. And as I said earlier, it's true that the Rosecrans field notes do not make reference to the fact that he put monuments down. However, those monuments are found at specific angle corners, and the defendant's own surveyor said, yeah, there's no other plausible explanation for those monuments other than that they were laid by the original surveyor. Unless there's any questions.
Thank you.
Thank you, counsel. Thank you both for your fine arguments. Case is submitted, and we are in the final lap. The last case for the morning is United States versus Batara, Molina, 21-8079. Counsel for the appellant, if you would make your appearance and proceed, please.
Good afternoon, Your Honors. Josh Lee from the Federal Public Defender's Office for the appellant.
Could you speak into the microphone, please, a little louder?
Yes, thank you. Josh Lee from the Federal Public Defender's Office for the appellant, Mr. Molina. The question presented in this case is whether a traffic stop violated Rodriguez versus United States. And that question involves two sub-questions. First, whether the officers prolonged the traffic stop. And second, whether reasonable suspicion supported the officer's decision to pursue a drug investigation. On the first issue, Mr. Molina's traffic stop was prolonged. Deputy Coxbill stopped Mr. Molina for speeding, but rather than diligently pursue the traffic-based mission of the stop, Deputy Coxbill deviated from that mission to gather up his drug dog and have it sniff the car for drugs. This ended up prolonging the traffic stop within the meaning of Rodriguez because during critical moments, the only other officer on the scene, Deputy Rhodes, was also assisting with the drug investigation and not pursuing the mission of the stop. On the second issue, and contrary to what the district court found, the deputies...
How much time was involved? How much time was involved in that? How much delay did that involve?
So the illegal detention was between 25 and 30 seconds. Those are the times that both of the officers were off task. That was enough under a substantial body of this court's decisions, most recently in United States versus Frazier, where the court said that Rodriguez is a bright line rule and that even a de minimis delay in the...
But is that time in addition to time that the defendant was instructed to roll up the window, get out of the car, and walk a substantial distance down the road? Those requests seem to be unrelated to the traffic stop. Is that the only time you're talking about, or are you talking about some other delays in addition to that?
No, those are the delays that we have challenged because during that time, Deputy Coxbill was readying his drug dog and performing the sniff. So...
Specifically, the time getting out of the car to roll up the window and walking back an extended period of time, not just on the side of the road, but walking backwards long enough to let the dog be cleared to examine the car.
Exactly. Those are the three moments that we contend prolonged the stop.
Could I focus on the rolling up the window?
Yes.
What purpose do you allege? Was there a traffic stop related purpose to the direction to roll up the window in your view?
Absolutely none. There was testimony from Deputy Coxbill. This is page 50 of volume 3 of the transcript, where he says, I know my dog, and I don't want my dog to put its head in the windows, and that's why we have them roll the windows up. In fact, the government admits in their answer brief, and I don't have that cite with me, but they admit that this was action related to the dog. And that's important because even though this delay of getting Mr. Molina to roll his windows up was momentary, what Frazier says is what we're looking for is a Rodriguez moment. A moment when there are concrete steps taken to further the criminal investigation and no one is working on the traffic stop. What Frazier also said is once you find a Rodriguez moment, and this was a Rodriguez moment, the detention is illegal from that point forward. So once he directs Mr. Molina to roll up the windows in the car and Mr. Molina does that, the detention is illegal from that point forward. The dog sniff occurs during the illegal detention. So that's why there was a Rodriguez violation. Now, the way that the government defends the rolling up the windows moment is they say, well, look, Deputy Coxbill is going to sniff the car. Going to have the dog sniff the car. Going to have Champ sniff the car. And so Deputy Rhodes can do two things. He can either let the windows stay rolled down and let the occupants of the car be exposed to this apprehension dog who could bite them, or he could tell them to roll them up, and we shouldn't punish him for pursuing safety. But this gets everything backwards because we assume that the deputies are not supposed to be doing a criminal investigation. So they're not being punished for promoting safety. They're being, we do suppression because they're not supposed to be doing a criminal investigation, and rolling up the windows would not have been necessary had they not been doing the dog sniff.
In other words, the fact that, in your view, the fact that if there was a safety motivation, it was a safety motivation linked to the fact that they were undertaking a separate criminal investigation.
That's exactly right. And
All right.
what Rodriguez says specifically is that safety precautions taken in order to facilitate a criminal investigation are a prolongation of the stop.
Well, so let's focus then on the criminal investigation, because the alternative argument advanced by the government was that there was reasonable suspicion for this detour. And therefore we can just justify it not as a traffic stop, but as a reasonable suspicion examination of a felony crime going on. So that's I think that's where I'd like you to focus a little bit, because to me, I really kind of agree with your first statement. It's the second one that's the troublesome one for me.
So I think based on what Deputy Coxbill knew at the time, everything that he learned was consistent with Mr. Molina taking a road trip during the height of the pandemic, when lots of people who didn't otherwise take long road trips, to visit family for at least a couple of nights and to come back. There's nothing unremarkable. There's nothing remarkable about that.
How about the third-party rental?
The
Which
third-party rental?
we have a number of cases where it's remarkable only in the sense that it is indicia of drug trafficking.
Two points about that.
Yes.
The first point is there are lots of reasons for third-party rentals, most notably that if you have poor credit, you're probably going to need to have someone else rent a car for you.
Well, I'm not going to plumb the depths of what the reasons are for third-party rentals. All we're talking about is whether there's reasonable suspicion here, which is even less than a fair probability, which is probable cause. So the fact that he had a reason that's connected to drug trafficking, he didn't need to have multiple encyclopedic other reasons that he factors into the equation, does he?
So this court has never said that the third-party rental without other substantial factors is enough to clear reasonable suspicion.
Well, let's talk about the other factors then. You've got a travel of a long-distance stay with a quick turnaround on the vehicle. I mean, it's like they're traveling across the country for the, quote, vacation, and yet they've got to return the vehicle in a short period of time. Why isn't that odd, consistent with our case?
I don't think it's at all odd. His travel plan was to travel and stay 2 nights with family members and then come back. I don't think this court has ever said that a travel plan of staying somewhere 2 nights is odd or unusual. But more importantly, this court said in Simpson that travel plans that strike us as inconvenient or unusual don't contribute anything to reasonable suspicion. 0. The only thing that contributes to reasonable suspicion, and this is from the court's decision in Lopez, is when the travel plans beg credulity, when it begs credulity that the purpose of the trip could justify it. And here, again, taking a long road trip during the height of the pandemic to visit family for a couple of nights is not even odd or unusual, much less bizarre and begging credulity.
How about the odor?
The odor, yes, in most situations, smelling a strong odor that can be used to cover the scent of drugs can contribute to reasonable suspicion, but not here. And that's because Detective Coxbill gave vague and contradictory accounts of what it was that he smelled. He said once that it was the fruity output of a vape device, another time that it smelled like a new car, other times that it smelled like perfume. And the problem with that is not just that they're contradictory, but also that a lot of the smells he listed are totally innocuous. This is in 2020, it's a 2020 rental car, it's gonna smell like a new car. They had vape devices in the car. If they're vaping, there's gonna be an odor from a vape. And unlike in a lot of this court's cases, neither of the deputies testified, oh, we smelled a new car smell, and people often use a new car smell to cover the scent of drugs. So really, with this...
In connection with Deputy Coxbill's testimony, he testified about the cover odor, right?
Yes, he said, I smelled a cover odor. It was either a vape or perfume or a new car.
Well, wait a minute. I thought in the connection with his testimony, as opposed to his report, I understand his report, he talked about smell sweet, all that kind of stuff. But in his testimony, that was consistent with him speaking about it being a cover order. And even actually in real time, didn't he say to the other deputy that he thought there was a cover order?
He did, but the problem with this, so let me back up 1 second. He contradicted himself at the hearing when he said it's a perfume and a new car, and then he was like, I don't know what I smell. But the problem with relying on him saying, I smelled a cover odor, is it's the equivalent of him just saying, I smelled something that I thought was suspicious, which that's not particularized and specific enough.
In this context, why isn't it? I mean, suspicious of what? I mean, obviously dope. I mean, you don't use the word cover odor because you're covering something.
So
why isn't that dope?
Again, by saying a cover odor, he's just saying, I thought it was a suspicious smell, which is equivalent to this Supreme Court case in Brown that I cited where the officer says, I saw something suspicious in the alleyway. And the Supreme Court said, you have to give details what it was. The reason is there's this...
The details. We do have the details, and they're a bit unusual. I mean, a lot of people have smell fresheners in their car, but here he described it as strong and as very overwhelming. And that to me is a pretty compelling piece of evidence, because you would not think it would be very suspicious for a person to travel in a car in which there is a very overwhelming artificial smell in the car. And so to me, that one may be the most persuasive to me, is that very overwhelming conclusion.
We don't have any reason to think it's an artificial smell. Let me give you an analogy. What happened here is if Deputy Coxbill said, I saw something in the console of the car. It was either a marijuana cigarette, or it was an ink pen, or it was a toothbrush. I'm not sure what it was, but it was suspicious. That's exactly what we've got here, and that can't count for anything. And I'd like to reserve the remainder of my time with the court's leave.
Of course.
Good afternoon, Your Honors. My name is Jonathan Topham, and I represent the United States from the District of Wyoming. Judge Ebel, can you hear me all right?
Counsel, we have a conflicting testimony apparently about how overwhelming this evidence was. Can the officer take the most incriminating statement of that and say, very overwhelming, that is something you probably wouldn't want to have in the car? Or do we say, well, you can't rely on that, officer?
I'm not certain I understand your question. I'm going to attempt to answer it. The way this case presents to the court here today, Your Honor, is the government obviously prevailed with the motion to suppress. And while the standard of review is de novo on the question of whether or not there was reasonable suspicion, the facts themselves are not being contested. And those facts are supposed to be viewed in the light most favorable to the government. So at a minimum, my position, Your Honors, would be that this court is not supposed to, under that standard of review, under that view of the facts, is not supposed to try to find the most innocent explanation for every single one of these facts in the record. That certainly would not be viewing those facts in the light most favorable to the government.
What about, well, yes, but what about the fact that there's inconsistent testimony or statements by Deputy Coxbill about what he discerned in connection with the vape? I mean, you know, we have the cover odor testimony, but we do have the testimony about fruity smell and that kind of thing. And I mean, people who vape cigarettes, I think that there is a fruity smell, and so, or some of them anyway. And so what, I guess the thing that I want to get at is two things. Although we're construing the facts in the light most favorable to the government, if there are conflicting facts, what is supposed to, and there is no explicit finding from the district court as to one set of facts or the other, what are we supposed to do with that?
Respectfully, Your Honor, I don't actually think there is conflicting testimony about the odor itself.
All right, why not?
Mr. Lee supplemented the record with Deputy Coxbill's report. That was not an exhibit at trial. Now, what he or not at trial, at the motion to suppress. What Deputy Coxbill testified to was this cover odor but he wasn't really sure what it was, which is exactly why he called it a cover odor. He wasn't calling it a new car smell. He wasn't saying that was for sure perfume. He was calling it a cover odor because he didn't really know what it was, but it struck him as suspicious. In his own words, as he said, it was overwhelming. And Judge Holmes, Your Honor, as I think you're right on point in that there is this sort of conflicting statement in this report, which he didn't really get a chance to explain at the hearing, where he attributes it to a vape. He didn't do that at the motion to suppress. And more importantly, as you pointed out—
Okay, and just to be clear, because perhaps I was operating under a misimpression here, the comments that report was not before the district court when it made its suppression determination.
It was not an exhibit. My recollection, I was there, was that, and I think the record would reflect this, Deputy Coxbill was asked by the defense attorney about, didn't you say this was a vape? And Deputy Coxbill said something like, I don't remember saying that. I don't think I did. I'm obviously paraphrasing that. But at the hearing, he did not attribute it to the vape pen.
At the hearing, he said it was the cover odor.
Right, and he could not identify specifically what that scent was. That's why he called it a cover odor. And what I was trying to point out is you're exactly right that in real time, his body cam, when he walks back to the car and he's going to start filling out that warning, one of the very first things he says to Deputy Rhodes is, I'm getting like a really good cover odor. So he didn't attribute it to the vape pen at that moment. He didn't know what it was, but it struck him as a cover odor, which is common in drug trafficking.
Well, that's the point. I mean, I engage in that colloquy with opposing counsel, but to the point, did he say what he discerned that cover odor to be? I'm not saying kind of drug, but was he saying it was a cover odor for, in his view, and we're talking suspicion now, did he suspect it was a cover odor for narcotics? Did he say that at the hearing?
I don't think he said that at the hearing. I think the inference is absolutely there. If it was just a strong odor, I don't think he would have pointed out to Deputy Rhodes, and he wouldn't have called it a cover odor, because that's what cover odors are. There was a special agent, Jason Ruby, who testified. He testified about the sorts of things law enforcement looks for, cover odors being one. That's a technical term for what they're looking for.
Work with me on this then. Let's talk about the potential reasonable suspicion framework here. What is wrong with opposing counsel's position that the travel plans here were not remarkable at all? I mean, that, as he put it, middle of the pandemic, he wants to go visit family, and so he does that with a quick turnaround, relatively quick turnaround. But the fact that it's an unusual travel plan, why is that indicia of narcotics trafficking?
I'm going to get to answer your question. The very first thing I'll say is this. This court has said over and over that any one of these sorts of things by itself will never give you reasonable suspicion. It's once you start to get a grouping of suspicious activities where you finally get reasonable suspicion.
Well, I get that, but he alluded to a case which he said made this zero. And if it's zero in an aggregation will do nothing for you.
Right.
And so explain that to me.
Bizarre and inconsistent travel plans absolutely can lead to reasonable suspicion, and we have those here. So Deputy Coxbill, maybe it was Deputy Rhodes, but one of the deputies testified they understood California to South Dakota. They didn't know the exact mileage. Turns out the round trip was like over 3,000 miles. They didn't know the exact mileage, but they knew it was a really far way to go. And Mr. Molina, the rental car was due back in 2 days. He hadn't even made it to his final destination yet. When he was asked about that, he then changed his story. Now it wasn't, hey, it's due back in 2 days. It was, I'm going to extend it. But of course, Mr. Molina, he could not extend the rental agreement. It was a third-party rental. He had no ability to continue or extend that rental agreement. As a matter of law, in fact, the agreement itself no longer existed. He had violated the rental agreement by driving the vehicle, and it was gone out the window. Deputy Coxbill, of course, didn't know that at the time. But we know as a matter of fact, he couldn't have extended the rental agreement. More than that, Your Honors, he was in a vehicle, I think it appeared he was with a romantic interest, and they had slept at a gas station the night before. That was something else that he shared. They had slept at a gas station. So this provided law enforcement the perception, one that I think is very reasonable, that they were traveling hard. And what we know from drug traffickers, mules in particular, that's exactly how they travel. They don't stay overnight at hotels. They make the trip quick, there and back again. So this was exactly like what we see in drug trafficking. In fact, I have probably about 3 cases.
Did he specifically say he had relatives in Sioux Falls?
That's not my recollection. I trust Mr. Lee. I don't think he's trying to misrepresent anything to the court, so I don't know for sure. That wasn't my recollection. For some reason, I thought.
But I didn't tumble to that. Maybe it's true, but I didn't tumble to the fact that he said, I have relatives, because that would have had a follow-up question, well, who were they? And I don't think anything like that was in the record, so I'm not sure that he said that. I thought he just never explained why he wanted to go there other than to visit.
My recollection is not that he said he was going to travel to relatives, but let's assume for one moment that is in fact what he said. I'm going back to Judge Holmes' point, that just raises the reasonable suspicion even further for this one simple reason. If you're traveling to see your relatives who are, I don't know, about 1,500 miles away, is it likely you know where they live? Because Mr. Molina, when he was asked where he was going, responded, Sioux Falls. He mispronounced Sioux Falls. I thought he said something completely different, but I'll concede, I think he said Sioux Falls. So this story that he would be traveling to visit family in a place he can't pronounce absolutely lends itself to reasonable suspicion.
I find the mispronunciation thing pretty darn weak. I mean, the reality is there are a lot of people from different heritages who can't pronounce Sioux Falls. I mean, I'll give you a number of places in Oklahoma, and I'll dare you to pronounce them correctly.
I'm sure not mispronouncing.
And so I don't know. That doesn't do anything for me. I mean, let me focus for a second here. And the question of sleeping in a gas station. What has to give all of us some concern here, I think, is there are poor people out there who travel, you know? That doesn't make them drug traffickers. And why does it automatically lead one to believe that they're doing anything other than what he said he's gonna do? He's visiting some people, he has to get back. What I want to focus on for a moment is your suggestion that he changed his story, because I don't recall that. So what did he say initially about the rental? I'm going to, putting aside the mispronunciation, I'm going to Sioux Falls for a for a vacation. How did he change his story?
That's a fair point. I don't recall the exact dialogue. What I will say is I believe he was asked what they were doing, and he said, hey, I'm going for a vacation, to which it was then pointed out to him, that's a pretty quick vacation. This car is due back in 2 days, to which he then has a solution for that, which is, okay, yeah, I'm going for vacation, and I'm going to extend this rental car.
Okay.
So it was sort of new information, but it was inconsistent with what was provided before.
Well, if it was just vacation, then that is not the same as visiting relatives. I mean, I was surprised about that statement about visiting relatives, because I think it would have had follow-up questions which I'm not aware of.
Yeah, Your Honor, again, my recollection is that it was more like for vacation. My perception of it was always that it was sort of like a romantic getaway with his girlfriend.
Since we have a little bit of time, why don't we talk about the rolling up the car window? I understand the argument that was made in your brief about safety. What I don't understand is why isn't that argument pretty darn problematic? I mean, it's one thing to say, I commend the officer for being concerned about the safety of the passenger, but if the reason that they were concerned about safety to begin with is because they were going to conduct a drug investigation, which involves the dog sniffing the vehicle, if we're not in the realm of reasonable suspicion now, why aren't we? Because that's a problem, isn't it?
Certainly. So let's talk about the car windows, obviously. Before I do, let me point something out. I've observed the defense attorneys love to quote the case and say a de minimis delay. Even a de minimis delay violates the Fourth Amendment. There's something in there. It has to be added, an unreasonable de minimis delay. Because reasonableness, we know, is the touchstone of the Fourth Amendment. So an officer who sneezes and has to stop writing his ticket, that's a de minimis delay.
Well, if
It's
they're
not unreasonable.
sneezing to pursue their criminal investigation, then that's a problem, isn't it? We talked about Rodriguez moment. That means moment. And if there is that moment in time, and when one officer is going to crank the window, other dog officers get in the dog, and the only reason that window's being cranked is in anticipation of the dog sniffing for dough, then why isn't that a Rodriguez moment?
So it's not clear to me that he was actually ordered to roll up his windows. I think that the exact quote is, hey, I'm gonna have you roll up your windows, and Molina agrees to do it. It's not, he doesn't say, roll up your windows right now. The other thing that I want to...
And the legal significance of that being what? Because if what we're talking about now is the period of time in which the law enforcement officers were focused on something else, whether they told him to roll up, whether they told him or ordered him to roll up the window, or whether they asked him to roll up the window, the point is, what's their objective at that moment in time? If their objective is to pursue their traffic investigation, whatever reason that could be, then that's one thing. But if their reason is, I'm getting ready to use my drug-sniffing dog, that's a problem.
So here's what I can see. Deputy Coxbill was absolutely engaged purely in a drug investigation at that moment. Deputy Rhodes was not engaged in that investigation. Deputy Coxbill handed off his clipboard and said, hey, will you please go and verify his address? There was a mountain of testimony about why that is important to the purpose of the traffic stop. Deputy...
he asked Deputy Rhodes to either get him to roll up his window, ask him, or order him, right?
He said, have him roll up his windows and get him out of the car.
Okay, so whether Deputy Rhodes knew why he was doing that or not, what he was doing was pursuant to what Deputy Coxbill was doing, which was pursuing a drug investigation.
I think it's important that we note people can have competing reasons for doing something. And I note that Mr. Lee, he filed a supplemental authority with this court. And that case was United States versus Whitley. It's not binding precedent of the Sixth Circuit. There's actually a case embedded in that. The case that is embedded in that, in fact, is, I wrote it down. Let's see here. It's United States versus Lash. And what's interesting about that case is there, a law enforcement officer, he approaches a vehicle, and he actually testified on the stand. He said, hey, I honestly didn't think this was worth writing a citation. But while he's up there, he sees a baggie hanging out of the guy's pants. And that alone made him say, hey, I'm gonna now continue my traffic stop. Now, obviously, he had two motivations there. The traffic stop itself, but he obviously was also investigating something else. So turning back to Deputy Rhodes, yeah, he was told to go roll up that window. We know that was only for the safety of the passengers when he left behind, but he never deviated from trying to issue that warning. And I made this analogy at the hearing. You know, if the four of us were asked to do one task, mow the lawn is the example I used, we're all gonna do it a little bit differently, but it doesn't make it unreasonable that we did it differently.
The difference is, let me, for the moment, spot you on this business of having two motivations. But the difference here is in that there was give me one. It seems to me there is no motivation that is related to the traffic stop involving the rolling up of that window. That could have been done. There was nothing that facilitated the traffic stop that involved rolling up that window. And if that's so, it doesn't matter if they were going to continue doing writing the ticket. The question is, when you told him to do that, split time moment, when you told him to do that, were you doing that because I need to have him roll up the window to facilitate the traffic stop, or were you doing that because you were told by somebody who was pursuing a criminal investigation? Seems pretty much like the latter. Why isn't it?
I'll be candid. I don't think rolling up the windows facilitates the drug investigation.
Coxbill said it did.
it's safety, right? Deputy Coxbill says, my dog likes to stick his head in car windows.
And why is that? Because the dog is going to go over there and sniff for narcotics.
But it doesn't make the dog more effective. There was no testimony that it makes the dog more effective. It doesn't make the odor more concentrated so that the dog is more likely to hit.
The point isn't efficacy. The point is attention of officers from either the traffic stop or from a drug investigation. They could be doing a lousy drug investigation, but if they're focusing on the drug investigation as opposed to the traffic stop in that split moment in time, what difference does it make?
Well, apparently the officer that said roll up the window, was he the one that also should have been spending his time on the traffic stop?
No, the officer who said roll up the window had at that point handed off the clipboard. So now Deputy Coxbill was the one who's the canine handler. He's the one who said roll up the window. He said that to Deputy Rhodes, who had at that point taken over the responsibility for finishing the traffic stop.
Well, did the person who was watching him roll up the window and walk back with him after he exited, was that the person who was writing up the traffic ticket?
No. So Deputy Rhodes, who had the clipboard at that point, walks up to the passengers.
So how do you know that delayed the traffic ticket at all?
I apologize. I didn't understand what you said. Please repeat that.
If the traffic ticket was being written up by the other officer who stayed behind, how do we know that the fact that Rhodes said roll up the window and walk back off the car delayed the writing up of the ticket at all? I thought that Rhodes, the guy who was doing the window demand and the walking back, I thought he was the one who was supposed to be writing up the traffic ticket.
I think you have a couple of the facts confused, and I'm certain I have not helped it. Deputy Coxbill made the stop. He then handed the clipboard off to Deputy Rhodes. Deputy Rhodes went to the driver's side where he was then standing in the middle of the road because of where Mr. Molina had parked.
Right.
Asked him to exit the vehicle and come back to the shoulder. They would be outside of traffic.
Right.
And so, yeah, I think, and he is the one, Deputy
Was
Rhodes
it
who
Rhodes
asked that.
or Cox that was writing up the traffic ticket?
It was Deputy Rhodes, once he got to the shoulder, began to confirm his address, Your Honor.
Then he wrote up the traffic ticket, so it did delay the writing up of the traffic ticket. Because Rhodes was doing something else before he wrote up the traffic ticket.
Which specific thing, Your Honor?
Well, I see your time is, you're already into your time, so that's enough, thank you.
Well, thank you, Your Honors, and it's good to see you in person with the post-COVID. So
Thank you, counsel. All right. I know you had some time, and we gave him more time. Let's just round it out, 3 minutes, and call it a day. Hard 3 minutes.
Thank you, Your Honors. I don't think I will take the full 3 minutes. I have three quick points I want to make about the record. One, Defense Exhibit H was presented to the district court at the evidentiary hearing. That's at volume 3 of the record, page 35.
That's the report.
That is right. That's the report. Second, and this is related, Mr. Molina did tell Deputy Coxbill when questioned about Sioux Falls that he has family there. That was in Deputy Coxbill's report. It's at page 5 of the supplemental record, which again is Defense Exhibit H. The last thing is, and also about the reasonable suspicion, is that my colleague mentioned things like that Mr. Molina was not entitled to extend the rental agreement, that by driving on it, he negated the rental agreement, that it was over 3,000-mile trip. None of that stuff was known to Deputy Coxbill at the time. That was testified to by Special Agent Ruby, who testified after the fact. I'm not even sure why the district court allowed that testimony. It's totally irrelevant to the reasonable suspicion inquiry. So I would ask that you reverse Mr. Molina's conviction and remand with instructions that the district court suppress the evidence.
Thank you, counsel. Thank you for your fine arguments. Case is submitted. Court will be in recess until tomorrow at 9 o'clock, right? 8:30 tomorrow. Thank you.